Christian's gonna be coming in a minute or two, so.
Yeah, I have tried every which way to try to do it PDF, to try to convert it to Word and very, and then convert it back to PDF, and it just gets all screwed up with the
Well,
format.
did you
So
get
I
to talk
asked
to
her
Joanne?
to type her name.
Julie's thing, is she here?
Like old school, and we went to we got it from building about 3 years ago. Ours broke and he's like, the building we never used.
Because someone must have have something or something.
It's we've got it.
Now I know
Yeah.
we need it.
You need it, come get it.
So,
JC's roll cases, the agenda, we should do, order, and it's a agenda.
Hey, good morning. How you
Good
doing?
morning, JC, down, on record, minutes for the previous hearing, which I sent in the week before. Yeah, staff update was just saying that this is 15 days. And then we start first. And I always have snacks.
Yeah, Lord.
Snacks are
The red
imperative.
hots. Oh, she got the nerds
I got
out.
nerds and red hot and gum.
Eric
That's
hates
the thing.
nerds, right? Have you had those clusters?
Technically, no, but you just have to remember you are on YouTube. Good morning.
Good morning.
Good morning.
Christian, this is Susan Bungo from the Building Division.
Hi.
She's observing.
Okay, great.
Amy, so she can help with the phones.
Do the horse show first.
Portion? I got you.
Okay. All right. Are y'all ready? Okay. Good morning, everyone. My name is Christian Waugh. I'm the Code Compliance Special Master, and I bring this July Code Compliance hearing to order. At these hearings, we follow an agenda, a copy of which you might have seen posted outside. The first item on the agenda is the call to order. The second item on the agenda is the pledge to the flag, so I'd like to ask you to join me. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you, everybody.
Good morning.
Good morning.
If any person decides to appeal any decision made by the Code Compliance Special Master with respect to any matter considered at this public hearing, he or she will need to ensure that a verbatim record of the proceedings is made, which record shall include the testimony and evidence upon which the appeal is to be based.
All right, and the next item on the agenda is approving the minutes from the Wednesday, June 19th, 2024 hearing, which is a record of what happened at the last hearing. I have a copy in front of me. I have reviewed it. Are there any proposed objections or modifications to the minutes as currently formulated? All right, I hear none, and I will approve the minutes.
Staff update, abated, and continued cases are listed up front.
Okay, so before we get into the cases to be heard today, I want to go over some things with you and tell you a little bit about how this hearing is going to proceed. Again, my name is Christian Waugh. I'm a licensed Florida attorney acting as what is called a special master. That's a fancy title created by law, but what it means is that Citrus County has hired me to preside over your hearing today. What I'm going to tell you during this opening statement applies to all of your hearings, so I'd appreciate it if you'd pay close attention. When your case is called, please come forward. You will be placed under oath. If you are appearing at a hearing like this for the first time, the county will call its case, and I will allow the county to present its case first. You will have an opportunity to cross-examine any of the county's witnesses, and then you will have an opportunity to present your case regarding the violation. That will be your opportunity to present evidence and to make legal argument. It is important that you take your time during this process because it is likely going to be your only chance to make your case to me. I will also ask whether or not you are contesting the violation. If you do not contest that a violation exists, I'll assume that a factual basis for the violation exists and proceed to ask you how much time you need to fix the violation or to work with the county. This method like if you're not contesting that there's a violation, you don't argue that there's something wrong with the property, it would be helpful for you to just tell me that, because then we can proceed to just get you an amount of time that you need to fix the violation and we can move on. You are by no means required to do so, however. If you don't think a violation exists, please feel free to make your argument, and you have that right. At any time during the hearing, I may have questions of the parties, witnesses, or staff. Before issuing a ruling, I will ask if there are any members of the public who wish to speak. And if there are, such members of the public will have one opportunity to speak per case. Such right to speak is not unlimited, and public comment should be focused on the case and made as briefly as possible. Although persons may be upset or even passionate about what they have to say, all witness testimony must remain civil, and you should not interrupt other witnesses, parties, or attorneys. In most instances, if you are found guilty of a violation, the law requires that you be given a time to comply before a fine begins. You must fix the violation by that date, or the fine will accrue for each day that you remain in violation. The law allows Citrus County to impose the accrued fine as a lien on your property. The county has the right to foreclose on that lien or to seek a money judgment against you after the lien has been recorded for 3 months. I encourage anyone here who has questions about their rights or about what I've just said to seek their own legal counsel, as I cannot serve as your attorney. In all cases in which I find that a violation has occurred, I will impose all costs required by county law. I incorporate this into all of my orders as standard provisions. If you bring your property back into compliance with the code during the time that I allow, that cost will remain minimal. Although it's only happened a few times in my years as the special master, I may continue your case if I find a need for further evidence or argument. You do have the right to appeal any order I make today as may be provided by law. Thank you.
First case today, Ty Horschel, case number 2024-828, Code Officer Amy Becker, page 17 of your agenda, expert on the case, Land Development Director Joanna Coutu. She's back.
Oh.
She's giving her notes.
I'm just waiting for
Yeah, no, that's fine.
That's okay. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
I do.
Thank you. Ma'am, can you please state your name for the record?
Vicki Clemens.
Okay. And may I ask what your relation to the property and/or Ty Horschel is?
My daughter lives on the property, her and her husband. I'm here because they were in an accident on Memorial Day, and they're still in the hospital,
Okay.
and I don't even live here, so,
But it's your understanding that your daughter is the tenant on the property?
yes.
Okay, all right. I just needed to understand
No, yes, she is.
what role you have, and we'll get to that. All right, thank you. Ms. Becker?
Good morning.
Good morning.
Amy Becker, Citrus County Code Compliance Officer. This is case number 24-828, accessory uses or structures, a violation of the Citrus County Land Development Code, Section 3102A. The address is 255 South Scarborough Avenue, Lecanto, Florida. The property owner is Ty Horschel. I have good service via posting of the property as well as the Lecanto Government Complex. I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos taken during my initial inspection on April 25th, 2024. Photos taken on May 29th, 2024 at my corrective action inspection. Photos taken on July 5th, 2024 showing the posting of the property. and my final inspection on July 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing and pre-hearing order, and a copy of the posting affidavit.
All right, so Ms. Becker, before we move on from here, I want to talk to you a little bit about the rules for these types of hearings.
Okay.
So normally, when someone appears on behalf of a respondent, which your daughter may or may not be as a tenant, but setting that aside for a second, in order to appear on their behalf, you either need like a power of attorney document or something like that, if I'm gonna have you just stand there as a respondent.
Okay.
Otherwise, you're basically a member of the public, and you will have a right to be heard.
Okay, that's fine.
Okay,
That's
all right.
fine.
Then,
You want me to sit down then?
no, it's up to you, you can remain.
Oh, I mean, I understand what you're doing, yeah.
All right, so, Ms. Becker, I don't know if the county attorneys wanna look at the exhibits or not. All right. Are there any other members of the public who are going to want to speak on this case? Just curious. All right, thank you. All right, Ms. Becker, let me take a look at these before I've got what's been proposed as exhibits A and B. All right, what's going on?
On April 25th, 2024, I conducted my initial inspection and observed what you see in the photos, a trampoline, shed, toilet, camper, and other items. And I did speak with the tenant, Samantha Stone, and I did advise her that she wasn't allowed to have anything on the property at all. And then I did not talk to the owner. I did try to call numerous times, and the call does not go through. And so as of my final inspection, the camper, basically everything's still there. I didn't see the toilet, but everything else remains.
Is it your understanding that there's a lease agreement between the owner and Ms. Stone?
No, I'm not aware of the lease agreement. I don't have a copy of the
Okay.
lease agreement. And my expert witness is Joanna Katu.
Okay. Good morning.
Good morning. This lot is very small, about 1/10 of an acre. It's medium-density residential, mobile homes allowed, but our records don't have any permits. It should be vacant.
Is it possible to get a permit for the mobile home, or if it's not a mobile, it's like a
Right, an RV, no.
RV? Okay,
Yeah.
all right, I appreciate it.
Thank you.
All right, so because there is no respondent here, I do want to hear from members of the public. Ma'am, feel free to tell me.
Okay. Like I said, what I'm here to try to figure out is how we can get into compliance. Now, I was told when I come down when this first notice, she was not available at the time. I talked to another one and told me what we had to do was take the wheels off, tie it down, whatnot, to make it stable, and then it would be considered more a mobile home rather than a camper.
Oh, I see.
But now, they've lived there for 3 years, and the owner of the property had it set up. When they moved there was a camper there. So that's the way he had it set up. And up until now, we didn't have a problem with it. So I'm trying to figure out what we need to do to put it into compliance, because my daughter's still in the hospital from the accident. Her husband is incapacitated from the accident.
Permanently?
No, it's going to
Okay.
be a while, though.
Okay.
It's going to be.
How is your daughter?
My daughter has multiple broken bones, and
Okay.
she's healing, and he had multiple.
She's got multiple broken bones since May, or
May
Memorial Day.
27th.
And she's still in the hospital?
Yes,
Okay.
I've been here since then. I don't even live here.
Okay. Are you living on the property?
I'm staying on the property with my 15-year-old granddaughter, yes.
Okay. Well, here's my understanding of, well, first of all, there's never, and I'm only speaking out loud, you're a member of the public, so
Right.
I'm not. But the way this really works is that my understanding of what the county's presented is that without a principal structure here, you can't use this parcel for anything else, essentially, no accessory uses. And right now, because there's stuff on the property, one of the ways to bring it into compliance would be to remove everything.
Right,
That's the main way.
right.
And I don't know if there's a way to convert an RV into a mobile home or something that would
Well-
abate the violation, but
I
I'm sorry.
No.
So I'd be curious just to hear from the county if there is a way to do that.
Unfortunately, removing the wheels will not convert an RV to a mobile home. There's a whole licensing thing that has to go, and I don't think that RV is gonna make that.
So there's theoretically, I mean, I'm not saying it would work in this
I
case.
understand.
But you're saying there is theoretically a way to convert, I'm just talking generally, an RV into something that can,
As
With
raw
enough
ma-
engineering,
As raw
or-
material, right. It's raw
Okay.
material perhaps. They're not, taking the wheels off would never do it. though.
I got you, all right. So, ma'am, I appreciate your feedback as a member of the public. I'm just gonna let you know, I am gonna find that there's a violation. I'm gonna ask what the county's recommendation is. I'm going to be granting an amount of time to bring the property into compliance, and
But
that's,
that's what I need to know,
Yeah.
how I can do that outside of moving everything off of it.
well, it doesn't, this is really more for the owner of the property, but
Yeah,
I'm gonna
but-
grant the owner of the property, or whoever's responsible, a certain amount of time. What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, and this amount is appropriate given the severity of the violation and the respondent's actions relative to this violation. We would also ask that it's the respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Now, this investigation's been going on since at least mid to late April, correct?
April 25th is when I conducted my initial
Are
inspection.
you aware of how the waste is being handled, or if it is being handled?
When I was out there, as far as the camper, it was tied into a septic system on the property.
There's a septic on the property?
Which is no longer, it's been taken off the slab. And let me just add too, on
It is
April,
off the slab.
pardon?
I'm
It
sorry,
is
ma'am,
off
so.
Yes,
right.
it is off the slab. On April 30th, I did call and leave a message for the tenant, Samantha Stone. And I advised her that in order to abate, she would have to remove everything from the property. So I gave her the building permit phone number so she could call regarding, because she mentioned, I want to turn a shed into a home.
Sure.
I said, that's going to be a building issue as far as, but you're going to have to go through the process.
Right.
So the only way to abate it this time would to be remove everything.
I agree. So what I'm going to do is, I'm gonna grant 2 months to bring the property into compliance, and if it's not brought into compliance as ordered, there'll be a $100 a day fine.
So basically, we gotta move everything off the property. There's no way to do it any
That's
other
the way to abate the violation, and that's the end of the hearing. Thank you.
Okay, because I talked to somebody, a code
You should
compliance
talk to the
officer.
county if you're an interested member of the public, but I'll issue an order on this.
All right.
All right, thank you.
Thank you.
Next case, Nona Vision Corporation, case number 2024-942. Code Officer Amy Becker, page 26 of your agenda. Expert on the case, Land Development Director Joanna Katu.
Amy Becker, Citrus County Code Compliance Officer. This is case number 24-942, a violation of the Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address is 8223 North Empire Avenue, Citrus Springs, Florida. The property owner is Nona Vision Corp. I have good service via signed certified mail return receipt for June 6th, 2024 and June 24th. 2024, I would like to authenticate the following documents and request that they be admitted to evidence. Exhibit A, photos I took during my initial inspection on May 16th, 2024. Photos taken on May 29th, 2024, my corrective action inspection. Photos taken on June 7th, 2024. Photos taken on my final inspection, July 16th, 2024. And photos from the property appraiser dated June 6th, 2023, and dated May 5th, 2024. Exhibit B, a copy of the notice of violations, a copy of the notice of hearings and pre-hearing orders, and copies of the signed certified mail return receipt signed for on June 6th and June 24th.
Okay, I do want to disclose to the county that about 7 days ago, I sent, on behalf of a client in Orange County, Florida, a demand letter to someone who I believe to be the owner of Nona Vision Corp. And it doesn't relate to anything in Citrus County, but I don't know if the county believes that would be a basis to have me not hear this or not. I'm prepared to look at the evidence as it is, but I want to disclose that on the record.
Thank you.
I bet, yeah. Okay, all right. Is there anyone from Nona Vision Corp here today? I don't see anybody. Then without objection, I'll admit Exhibits A and B as evidence. Go ahead.
On May 16th, 2024, I conducted my initial inspection and observed the property to be in violation. On May 17th, a notice of violation was issued for site development and development order without a development order or permit. On May 29th, I conducted my inspection at the property and researched, and no permits have been issued. And as of my final inspection on July 16th, you'll notice the pile of trees has been removed from the county right-of-way.
Yeah.
I have expert witness Joanna Coutu.
To make sure, okay.
Yeah,
You're fine.
what's going on?
It's a residential lot on the Citrus Springs Master Plan. They did apply for a permit back in November of 2023. After a couple rounds, it was actually approved on March 6th of this year. It's been awaiting fee payment and issuance since March 6th, and there's been no activity since
Since
then.
March 6th?
Right,
So I just want to make sure I got it right. So they applied for a permit to build on the property.
correct.
And did that include what appears to have happened, like a site clearing?
Yeah, the tree removal would be part of the permit,
Okay.
yes.
Okay.
But they haven't picked it up
They
or
just
paid.
haven't paid for it.
Haven't paid for it to get it issued since March.
All right, I appreciate it. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $2,500 along with administrative costs to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the irreversible damage caused by the violation.
And if I recall, what is the maximum fine? Do you know? It's 5,000?
$5,000.
Okay, all right. Is there anyone from the public who wants to be heard on this case? All right, I don't see anybody. What I will do is find that a violation has occurred and assess a one-time fine of $2,500. Thank you.
Next case today, John C. Hochtel Jr., Pamela L. and Linda L. and John III Hochtel. Case number 2024-495, Code Officer Cody McGuire, page 16 of your agenda. Expert on the case, Water Resources, Deborah Burns.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Oh, and in case number 24-828, just for the record, that evidence was admitted. Good morning.
Morning.
Yep.
Cody McGuire, Citrus County Code Compliance Officer, case number 202400495. Conflict with Central Water Facilities, a violation of Chapter 42, Article 2, Section 42-39B of the Citrus County Code of Ordinances. Sewer. I'm sorry.
So I
Ad-
can read, so it's fine, you know.
2722 North Comanche Point is the address. Property owner is John C. Hochtel Jr., Pamela L. Hochtel, John Hochtel III, and Linda Hochtel. Goods service signed certified mail return receipt and posting at the county government building. I would like to authenticate the following documents and request they be admitted to evidence. Exhibit A, copy of the notices from utilities. With the connection of a 365, 270, 180, and 90-day notices, and the final 30-day notice. And Exhibit B, a copy of the notice of violation, copy of the notice of hearing, and a copy of the signed certified mail return receipt in a pre-hearing order.
Are any of the Hochtels here? All right. Is there anyone from the public who wants to be heard on this case? All right. Okay, without objection, what's been proposed as Exhibits A and B are evidence. Actually, just give me a second to look through this. All right, please proceed.
Okay. On March 13th, 2024, I received a complaint from the I received a complaint that the property had failed to connect to central sewer systems. After the 365-day notice period, the property owner was found to be in violation of the above ordinance. The property remained in violation at my corrective action inspection on June 4th, as well as my pre-hearing inspection conducted on July 16th, 2024. I have had contact with the property owner, and they're aware of how to become into compliance, and I will now turn this over to my expert, Deborah Burns.
Okay. Good morning.
Okay, so I have been in touch.
If you would, bring the
Sorry.
mic down, thanks.
I have been in touch with him. He did pay all his connection fees on last Monday on the 8th.
Oh,
July 15th, his plumbing permit has been issued. And it was part of the septic to sewer grant program that has just been extended to the end of September. So
what does that mean?
It was a grant to assist them with the connection costs.
Just specifically for them or for a bunch of people?
Just certain areas.
Okay.
In the Montezuma waters. And so he has 3 months before that expires. So he's well aware of everything, and he's trying to get everything into compliance before that expires.
I just want to make sure I understand. So are you telling me that he's done everything except actually connect?
Correct. The connection has not been completed
He's paid
yet.
the money that he needs to pay?
Yes.
So in order to connect, what does he need to do? Get a contractor out there, or?
Yep, the plumber. The plumber has to make the connection to the sewer. They have to abandon the septic, and they have to pass all inspections before they'll qualify for any grant reimbursement.
Okay. And you're saying that he's got 3 months to do that under the grant provisions?
Correct. Yes.
Well, then what does the county want me to do? Find a violation and grant him enough time under the grant? I mean,
Well, the permit hasn't been finalized yet.
oh, I see. The permit hasn't been finalized.
Correct.
Right, but what you're saying is if he does that within 3 months, am I not understanding?
Correct.
Correct.
If he's done in 3 months, yes, then he gets reimbursement. But if he does not connect within 3 months, he's not eligible for any reimbursement, and then it will be a violation.
Okay. All right, well, what's the county's recommendation?
Citrus County Code Compliance Division respectfully requests that the special master assesses a fine of $50 a day along with administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally find that it's respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I have a question. So on the notice of violation, it says that on March 19th, 2021, the property located at 2722 North Comanche Point, the following violation was witnessed. But I don't think you meant March 19th, 2021, did you? Because I have a notice of requirement to connect within 365 days that is dated August 26, 2022. So I'm just wondering where y'all got the March 19th, 2021 date.
I got the 13th. Maybe it was a Scrivener's error.
Should it have been March 19th, 2022? Or maybe y'all just waited to bring it for a year and a half? Or
It was a previous owner when the original 365 started. And he was-
So on the notice of violation that's dated April 24th, 2024, it's addressed to 4 Hochtels, including John Hochtel Jr. On the August 26, 2022 document, it's just addressed to John Hochtel Jr. The one, and actually, it's notarized by you, Ms. Burns, on January 26, 2022. But it's dated August 26, 2022. So now I'm even more confused. I don't candidly think it's relevant for the violation. In other words, if due process is the issue, obviously they have notice, several notices here, but these dates are all a mess. Do you have copies of what I have?
The original original 365 to the Hochtels was August 26th of 22.
All right, look at the bottom of that document.
Mm-hmm.
When does it say it was notarized?
Oh, 26th of January, yep, that was a typo.
I presume you meant the 26th of August?
Yes.
Okay. Was it just prepared in January, you think, originally, or?
No, that was a previous letter that did not get updated with the date.
Okay, well, that's what I meant. All right.
Yep, that was.
I think that's plausible. Again, I don't think it matters for notice purposes, but let's look at the other stuff. All right, I'm going to find that a violation has occurred, grant 90 days from today to abate the violation if it hasn't been brought into compliance within 90 days, $50 a day. Okay? Thanks.
Thank you.
Next case, David S. and Pamela J. Finley, case number 2176351. Code Officer Cody McGuire, page 13 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Please state your name.
I'm Melissa Johnson.
Mr. Johnson.
Thank you.
Good morning.
Good morning, how are you?
I'm good. And may I ask what relationship you have to the Finleys?
Yes, they're my parents.
They're your
I'm
parents.
also an officer of the company that owns the land.
There's a company that owns the land?
Yes, it's Miss Finn's Orhouse LLC.
Miss Finn's Orhouse?
Yes. Don't ask my mom.
Well, Orhouse LLC. And do you know when that LLC became the owner of the property?
I filed those last year. I did not bring that with me, though.
That's okay. I mean, and so basically, you're representing that the Finleys, David and Pamela, were the owners,
Yes,
and then they conveyed ownership of the property to Miss Finn's
That's
Orhouse
correct.
LLC.
that's correct.
Okay. And you're an officer.
I'm an officer
All
of
right.
the company, yes.
Thank you. Actually, this is an appeal, right?
Fine appeal,
This
yes,
is
sir.
appeal, yes, a
Okay.
fine appeal.
All right, so what's the basis for the appeal?
On the fine appeal, we were under the assumption that we had fulfilled the requirements as we were working to have it rezoned. I will admit that I'm bad with dates, apparently, and I thought we had a little bit more time due to like the flooding that had happened out in Ozello. We did take all of our survey results. Unfortunately, the gentleman who did those, he lost all of his equipment, files, everything. So we've been working with Michael Wilborn on the PUD so that we can get the rezoning done. Brenda McKenzie is also one of our advocates to help us with that rezoning. And we are on the agenda to have that rezoning done. I believe it's September, I think it's August or September, for the September agenda. I've worked very closely with both Cody and JC to ensure that we have everything that we need to have done. It seems like sometimes when we would call and it would be, oh, now you need to do this. So it's never been exactly like, just bring it, stop doing the business or get the rezoning done. So we've been working on the rezoning and we have stopped doing the business, moved the items off the property that was requested. I think there was some misunderstanding on some of the pictures, that was a different property, that some of the pictures were being taken from. So we're just requesting that we appeal the fine and allow us the 2 months to
Has
get
the property been brought into compliance?
Yes, sir.
All right, I don't remember all the details. Does the county have a copy of the order, or?
Yes, sir.
I'd love to see it. I mean, please feel free to show Ms. Johnson.
Yeah.
But whatever the county has to present, I'd like to review. And just so I know, is there anyone from the public who's going to want to be heard on this? Okay.
Give him everything.
Here, do
you
you want
wanna
all of his exhibits, because he has the photos and
I do want everything, because I just don't remember
That's okay.
this property
It
exactly.
has been an ongoing issue. I think it's been almost a year and a half.
Well, I presume it was my order, but I don't remember ever granting I've never granted that much time
It
for
was
anything before.
No, unfortunately,
So-
you were not available.
Oh, it was not
your
me?
alternate.
Oh, wow,
Yes.
okay.
in which we feel fortunate because the hurricane did show up.
Yeah, of
The next,
course.
couple months later, and
Right.
we have spent a lot of time recovering the properties out there.
All right, I just want to refresh my recollection
No, you're
about
fine.
this. All right, thank you. All right, so let me just take a look at this real quick. First, does the county have a position on the appeal? I just want to, I don't know if the county does. I presume that it opposes it if it's here for a hearing.
No, only you can grant the fine appeal, so it has to come before you, and I believe she was just found in compliance yesterday.
No, I know.
No, I'm
I'm
not.
just asking if the county has a position on it. Normally you do.
Our case is the property failed the compliance inspection.
At the
and
300-day
At the
deadline.
300 day, so.
I understand, okay. All right, so let me just take a look. It'll just take me a moment to kind of read this. Okay. All right, I appear to have two copies of the order, and then order imposing fine was actually signed by me. When was it brought into compliance?
July 2nd.
July 2nd. So how much of a fine we're talking about? How much of a fine has accrued up to this point? If it's 50 a day, 45, couple $1,000.
Now, I will say that I had made several phone calls to ask for them to come out. Some of the things that they were saying that we were not in compliance was, I don't believe, like one example is when I had called, it was, you're selling ice. Well, we are allowed to sell ice as a bait and tackle shop, so that was a misunderstanding. Another item they told me was, you have tables outside, and
Let's
those
talk about the
tables-
ice first. So
Yes.
given, let's assume that's all
That
true.
was already told, that was a misunderstanding. so.
Okay, but let's assume that that's true. Was that keeping you from being in compliance, or were there still other things outstanding at that time?
Well, the other items they said were the kayaks that were still on property.
Mm-hmm.
When I asked him what kayaks, he said there were 6 red kayaks and a kayak rack. Those 6 red kayaks and that kayak rack were actually located on a different address on 14014 West Ozello Trail.
Okay.
And had it is actually a commercial
Well,
property
but what I'm
over
asking
there.
is, in either case, were those the only things keeping the property from, hold on.
Oh, yeah.
Yeah. Were those the only things keeping the property from being in compliance at the time that those misunderstandings
Well,
occurred?
the request was to cease doing the business. I did not know that we needed to cover up signs. So they said that the signage, then they brought up, oh, you have to cover the signs. It seems like every time that we had done something, we were said, oh, no, now you need to do this. And like the last one was tables. And the reasoning for the tables was because you could serve food on them. I could do a lot of things on tables. We actually, allow the fishermen and the scallopers to clean their scallops on the tables.
So I think the answer to my question was,
I don't know. I honestly, I don't know because there's no list that dictates exactly what we
right,
can and cannot do.
yeah, that's true.
And so therefore, when I had called and talked to both JC and Cody, I asked them to come out, and finally, I said, I did get JC to come out with Cody, and we walked the property, just so we can understand exactly what it is and at that time, I think there's still just the tables were the only concern that we had.
Okay, so actually that does answer my question. No,
Yeah.
those were not the only things, and that's helpful. But I guess, the issue with a violation like this, where there is no exact checklist about there's a lot of ways, but what that means is there's a lot of ways you can violate if you don't work with the county ahead of time, which is part of the point.
Right.
And that's what brought, the case before the alternate special master in the first place.
And we have been working with the county, and I think that's
Yeah,
where I'm talking
yeah.
about.
Well, you're in
I've had
compliance.
very many phone calls, as well as finally requesting them to come out and meet with me, because it seemed
Actually,
like
I
we
think
were
I've
always.
seen this. Maybe I didn't have this case, but I know I've seen this property in a case before.
Well, we've had the BOCC meeting, we've had several of these code compliance meetings in the past too. So this will be the third code meeting on this case.
Let me just look at the rest of the stuff.
And then we had a second violation that was already also complied with, which was an outbuilding that was on one of the pieces that was zone residential. So we removed it. Has someone-
What did you have to do to bring the property into compliance?
Well, what we were told that we would have to either have the property rezoned.
Did you have the
Have-
property rezoned?
We are working on that. That's what the PUD, we were on the agenda for September. We did come in front of the BOCC originally to request a rezoning last year, and it was denied. We were told that we could come back in front of them once the PUD was
Here's my
submitted.
very specific question.
Yes.
In order to bring the property into compliance, I understand that maybe rezoning was one way. What were the other ways?
Cease doing the business
Cease
that
doing
was not,
business.
which was the sale of, or rental of kayaks, going, I think it's the, what do you call that, chartering of
Mm-hmm.
airboat tours, and
So there were ways to bring it into compliance besides rezoning.
that's correct.
Okay.
And we did cease the activities that were requested. At the time, we had a food truck out there.
Within 300 days?
Yes, the food truck was removed. Actually, we were told just to take the stickers off the side of the
Well,
food
then
truck.
why
'cause
wasn't it brought
open.
in, why didn't the county say it was brought into compliance within 300 days if they stopped doing the
pictures-
offending, I'm sorry, hold on,
Oh, sorry.
thanks. If they stopped doing the business within 300 days?
There was still advertisement of airboat rides, fishing charters, and
I think that was it. There was no kayaks.
Ma'am, and so here's the way these hearings work.
Oh, no, I'm
You-
sorry.
you-
I'm just.
That's okay. It's happened several times now. So just, if you don't mind, direct your comments to me, but I would like to hear from the county right now. So, Mr. McGuire, you're talking about advertisements. Were the advertisements on the property, or were they in print, or?
they were on the property.
Okay. And so the reason why, did you ever go out for an inspection, a compliance inspection, and the only remaining violation was the advertising?
For my compliance inspection?
Mm-hmm.
Yes.
Okay, and when was that? Do you know?
For the compliance inspection, whenever it came into compliance, was on July 2nd.
Well, was there, what I'm trying to get at is, before, it says right here they were supposed to take corrective action by May 16th, 2024.
That's when the advertisement remained.
Okay, so you went out on or around May 16th, 2024 and saw the advertisements.
Mm-hmm. Yeah, when I was out there on the 16th, it revealed that the violation had not been abated. There was still advertisement for airboat rides and fishing charters.
But to the best of your knowledge, the property was not being used for that. at that time? Or do you know?
Well, I've seen the airboat there.
And that advertisement was removed after?
Yes, sir.
Well, I mean, was the property being used with an airboat on or around
We
May
have a-
16th, 2024?
Sorry, we have a separate LLC that's totally different. They do airboat charters. We are no longer selling those airboat charters through the property like as requested, but people can book those on that fishing, just like any other fishing captain in the area. They can go out there and book that. We're just no longer allowing them to come inside and advertising those inside the
All
establishment.
right, the appeal's denied. Good luck.
Next case is on today's agenda. Mark Ball, case number 2024-802 and 2024-803. Code Officer Brandon Norman, page 6 and 7 of your agenda.
Mr. Ball, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Your name, please, for the record?
Mark Ball.
Thank you.
Good morning.
Good morning.
Good morning.
Good morning.
Brandon Norman, Citrus County Code Compliance Officer. This is for cases 2024-00802, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and case 2024-00803, abandoned, unserviceable, and unlicensed vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is for 3077 East Buck Court in Inverness, Florida. Property owner listed as Mark Ball, and I have good service via posting of the property in the Lake Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A will be photos taken during initial inspection on April 23rd, 2024, my corrective action inspection done on May 31st, 2024, and a final inspection done July 15th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, along with a photo posted of the notice of hearing of the property,
Are you presenting both cases
if that's okay.
at the same? No, it is.
Yeah.
So does that make sense that there's two alleged violations and he's presenting the case for both of them at the same time?
It does.
Okay, then I'd like to ask you to take a look at these documents and just let me know if you have any objection to them being evidence in this hearing.
This is for 803.
And take your time.
This is for 802. And then exhibits A, then B is on the next stapled copy.
Okay. Yes, I don't disagree that we're in violation on this. That what it is that there's a tenant there that I can't get out right now, and I've been trying to evict him, and we put in a 3-day notice, which I have a copy of on my phone. We put in a 3-day notice about 20 days ago, and then we were just informed on Monday that there wasn't the proper format, that the format's been changed, so we have to start over again.
Who told you that?
At the clerk of the court. They didn't initially tell him that when he went, my property manager went to file for the
Clerk of the
eviction.
courts told you that it was an improper form?
Format, that there's a new format as of
What
Governor
business does the
DeSantis.
clerk of the court have telling you that? I mean, did you try filing the eviction
Yes,
and they rejected it?
yes.
I would just go get a lawyer if you need, if you feel like you need one. But, so I understand you're in the process of getting rid of these folks. Would you mind do you have any objection to these exhibits?
No.
All right, I would like to take a look at them just so that I have an understanding of what's going on at the property and to give you a fair amount of time to, bring the property into compliance. The reason why I need to look at these is that if it's really bad and there's some kind of a septic issue or a health, safety, sanitary issue, then regardless of your efforts, I have to do something faster. But if it's not, I can give a little bit more time. So that's why I just need to see that.
I understand.
In the meantime, is there anyone from the public who wants to be heard on these cases? I don't see anybody. Okay. Without objection, what's been proposed as Exhibits A and B in each case is admitted. Mr. Norman, do you have any reason to disbelieve anything that Mr. Ball has said today?
No, not at all. Mr. Ball has been very communicative. We've had several phone calls. He's been in constant communication anytime something has happened or if something has changed. As far as the junk and debris case, they are pretty close to coming into compliance. The unserviceable vehicles, they haven't changed at all. But no, everything that Mr. Ball has said is
All right.
accurate to my knowledge.
What's the county's recommendation?
We recommend $50 per day along with administrative costs begin after the day that you deem sufficient. It's based off the actions of the violator once they were revised. We just ask that you make the respondent responsible to contact us so that we can do a reinspection.
Mr. Ball, what I'm going to do is I am going to find that the property's in violation in each case. They don't look that bad to me. I'm going to grant 60 days from today to abate the violation. Hopefully that's enough time to refile, get an order, do what you need to do.
Okay.
And if the property is not brought into compliance on either of them, there would be a $50 a day fine.
Okay. Could I ask for 90 days? Because as we're doing the eviction and we had to start over again. So as of yesterday
So evictions
morning.
can proceed under what's called again, I'm not your lawyer. I encourage you to seek legal counsel, but evictions can avail themselves of what's called the summary procedure, meaning that once there's been proper service, they have 5 days to respond. And if they don't, you can get a default judgment. So theoretically, if they were served today, you could have them evicted by next week. So I think 60 days is sufficient.
Okay.
All right? Thank you.
Thank you.
And to
Thank you.
clarify, that's $50 fine for each case.
For each
That's what I
case,
said.
yes,
Yeah.
for each case. Yes, thank you.
Next two cases on the agenda, Joseph G. and Diana S. Costa, case numbers 2024-00472 and 2024-00473. Pages 9 and 10 of your agenda, Code Officer Cody McGuire. Oh. Wait, who's that? Oh. Okay, we're gonna I'm so sorry. Oh, he's here.
No, he's here. Yeah.
Pages 9 and 10 of your agenda. And Joanna Catuzzi, expert. I'm doing great. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Please state your names.
Diana Costa.
Joseph Costa.
Thank you.
Good morning.
Good morning.
All right. Welcome back.
Thanks. Cody McGuire, can I run both these together?
It's the same property.
Yes, okay. Cody McGuire, Citrus County Code Compliance Officer. Cases number 202400472 and 473. A violation of Citrus County Development Code, Section 4002, site development without a development order or permit, and special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102A. Address is 6522 West Mena Lane, Dunellen. Property owner is Joseph G. and Diana S. Costa. Good services posting at the property and posting at the Canton Government Building. I'd like to authenticate the following documents and request they be made into evidence. Photos taken during an initial inspection on March 13th, 2024. Corrective action on June 13th, 2024. And my final inspection conducted on July 16th, 2024. Exhibit B is a copy of the notice violation, copy of the notice of hearing, copy of the posting affidavit, and a photo of the notice posted on the property, and a pre-hearing order.
Are these the same proposed exhibits for each case?
Yes.
They're identical.
Well, one's a site development, and then one is storage.
Are the documents that you're proposing to put into evidence identical? Are
Yeah.
they the same photos?
No.
No, okay, so there's gonna be a different Exhibit A on one case than in the other case?
Yes, sir.
Okay, all right, so ma'am and sir, and may I ask, what is your relationship to each other? Are you
Husband and wife.
husband and wife? Okay. Then Mr. and Mrs. Costa, can I ask you to take a look at these documents and let me know if you have objections to them being evidence in this hearing? Or alternatively, if you're not contesting that a violation has occurred, we can skip past some of that, but just let me know, it's okay.
I also have my own.
Okay,
to
then let's
submit
look.
as well.
Then I want you to look through these and let me know if you have any objection.
was dated last 2023. This is the first set?
Do you have any objections to these documents being evidence?
Um,
And I understand you have your own.
Yes, I
and
know.
when I get to y'all, I'm gonna ask to see those as well. And, but do you have any objections to those being evidence?
no.
Okay. And just for, so that I can clarify on the record while they're looking through this.
Yes and no. One of the sky photos from, I guess, the satellite was taken on July 3rd, 2023.
Mhm.
We didn't own that property at that time.
Okay. They use that as a reference so that you can see a before and after, so I'll probably admit it, because it's relevant to show whether something's been done on the property. But so one of the cases is essentially, that, you know, there's been development without a permit. And then one of the cases is that the property is being used for something, whether it's storage or, you know, in other words, something's on the property without the principal use being established. Does that make sense?
Yes,
Okay. Are you contesting both cases or just one or?
both.
Okay, got it. And is there anyone from the public who's going to want to be heard on this case?
Officer McGuire, I think I kept part of yours.
All right, I don't see any response. Okay, what's been proposed as exhibits A and B in each case are admitted as evidence, but I would like to hear what's going on.
Okay. On March 13th, 2024, I conducted an initial inspection and as of the property being in violation, a notice of violation was issued for the violation of the ordinances listed above. On June 13th, 2024, I conducted a corrective action inspection and as of that the properties remain in violation. I've had contact with a young man at the property when I posted it and gave him my business cards for his parents to call. And I received an email for a request for permission to stay on the property as the home was being built. As of my final inspection on July 16th, the property remains in violation and no permit has been issued.
So it's your understanding that, and I'm going to definitely hear from the owners. I just want to know what your understanding is. It's your understanding that this is a vacant parcel, or should be vacant, but that the owners intend to build a home there. That's
And-
your understanding?
Yes, sir.
And they have, is there a copy of the request to stay on the property, or is that something y'all have?
I have it.
I have it.
Okay. Is there anyone else from the county who wishes to testify?
Joanna Coutu, Land Development. It is a mobile home zoned lot, rural residential mobile home. They do have a mobile home permit application. It's been approved since May 20th, but it needs fee payment and issuance. So,
Have you reviewed the request to stay on the property?
yes, we do not allow those for mobile homes unless there's some extraordinary circumstances because those are usually installed same day. There's no need to live in an RV while a house is under construction. This is a mobile home which is set up.
Okay, so what you're saying is what's on the property right now, they would not be able to get a permit for?
Correct. Well, they have a permit application for the mobile home.
A mobile home, right?
Mobile
No, I
home,
know.
right, right. But the other stuff, no. Yeah, not living in an RV and not the other things without,
Okay,
permits.
so it's your understanding, and the county's position that they have a request on they actually have a permit for a mobile home that could be picked up.
Correct.
It has not been picked up.
Correct.
And it needs to be paid for.
Correct.
And let's assume that they do, then what that would entitle them to do is not to live in what's on the property, but to install, I use the word install, but I don't know if
You're-
construct is a better word.
Right, no, you're fine.
But a mobile home.
Correct.
And as part of that permit, do they have to provide what the proposed mobile home would be or look like, or the size?
Right, and they did do that, and it's been approved and ready to pick up. So we have a approved mobile home permit, just not issued since May for whatever reason.
Now, let's say they get that,
Mhm.
and that we get through this. Would that enable them to have certain things on the property, like coolers or propane tanks or what have you? Like
Yeah.
things that you kind of as an ancillary matter, need to
As long
live?
as, right, as long as we're not encroaching into the junkyard type territory, yes, you can have those kind of things accessory to a principal structure.
Okay, all right. I think I understand the county's position. I'd like to hear from you guys.
Do you want me to enter into exhibits first?
Well,
Would you like to see
first,
those? Or?
I guess I want to ask you, does what they said make sense to you?
Yes and no.
Okay.
So, we're not from here. We come from big city.
What big city?
Originally Fort Lauderdale.
Oh.
We moved to a small suburb outside of Polk County 8 years ago to get away from Fort Lauderdale, and that turned into Fort Lauderdale.
I see.
We sold our house in Polk County and bought land up here to build on.
Okay.
Which we plan on building a manufactured home.
Okay.
We did not know originally, in good faith, we hired a company to just come out and clear our land. We bought it free and clear. We don't have financing on it. It was ours.
Good.
They did not disclose that we needed a permit to clear part of the property to where we would put our mobile home on. And again, we still were not here in this county, so we had no idea. The only thing that we did look up was if we could have an RV or a camper on our property while our home was being built. And what says on your county or however website I looked at, it says for up to 12 months, we can have it on there while our home is being built.
For up to 12 months, you can have an RV?
Camper. It's a travel
camper.
trailer. Yep.
Okay. What code section is that? Do you know?
I am not sure, but that's where we Googled it, so that's why we
Okay.
bought the camper
Then
and
we'll
we're
get to that.
staying in it.
All right, so it's your understanding, and it has been your belief, that having an RV while the property or while the house is being built is legal.
Correct.
Okay.
Also, on my permit, in small letters where it was approved, it states that my mobile home size, the model of my home that is presumptively to be on the property. It also states that the property owner must submit a letter in writing asking permission to stay on the RV on the property during the construction time. I said, it also states that the site review approved for the home and the mobile home only must retain at least 23 trees. 23 trees is my front gate line.
All right.
All other trees are staying on the property. We only cleared what was designated for our well septic and our manufactured home to go on there.
I take that as an argument that even if there was a requirement that you get a permit beforehand, no harm has been done because it'd be the same situation as we're in.
Correct.
Okay.
And we also are no longer living in that camper since I got that letter, and I submitted a letter since we got what was posted to our front gate, which he also handed to a minor. We've made arrangements to stay in a friend's home, also in Citrus County, until our manufactured home is built. We also have a 60-day closing. It's not something I can just go tomorrow and buy. So to argue what she's stating, I could just go put it on my property, no, I can't. It's also a 6-week build time from the time of my 60-day closing.
I don't think she said that, to be fair. I mean, I didn't take it that way at any rate. And at least, I, as a special master, am usually required to give a reasonable amount of time to bring something
Right.
into compliance if it's not in compliance. But what I'd like to ask you to do is, can you show the documents you just talked about
Yep.
to Mr. McGuire and or Ms. Katu? Because I'd
Absolutely.
like them to be
I
potentially.
also have the letter that I sent, and I also followed up with an email saying the
Okay.
same thing.
All these things, I think you should request to put into evidence, because I'd like to see them. But
Yes.
I'd like to know if the county has objections.
This box right there. Do you want me to have?
All of
the
it,
letter?
all the documents. Do you have copies of everything,
Yes.
or, okay. Now, I don't know how this is gonna shake out yet, but what I wanna share one of my thoughts, that I had while you were speaking, which is, even if there's a statement about the RV in that, if the law says something different, it's possible that a staff member screwed up. I'm just letting you know, I'm not, I just don't know the answer yet, and I'd really like to know that code section about, that you found about the RV.
So I
being-
Googled if we could.
I know, and I
be
can
in our
Google
RV,
too.
And
I've got
we
the
Googled
code.
it, and it pulled up the Board of Counties.
Sure, it
yes.
should, but see, there's a lot here.
Yeah,
This is
to
this is
go
it.
through and find it.
So
yeah. It says no more than 12 months that we can be in it there.
but there are people here who know that inside and out, so I think we'll get to the bottom of it. Okay,
Of the company that I hired.
okay.
And of our new landlord.
I think that's relevant for the, just anticipating potential county objections. I mean, if there are such text messages, I
It
think
is
it's.
also a Citrus
I'm sorry,
County
ma'am, hold on.
business.
I think it's relevant for, if I did find that there was a violation, the amount of any damages, because it would show their attempt to comply. I'm sorry, what were you saying?
The company we hired from when we hadn't even moved up here yet, they're a local Citrus County business out of Floral City.
Ms. Katu, while we're waiting, are you familiar with the code section they're talking about? I could probably find it, but it would take me longer. Okay, all right, that'd be great to look at, thank you. All right, so for the record, I've been directed to section 3140 of the Land Development Code, and specifically table 3.2. So I'm just gonna take a look at the whole thing so that I can better understand.
Quick question, there's an exhibit C, it's text messages between a Nikki mom, and it's not dated. I was like to inquire as to the relevance on that item.
That's our new landlord
Our new rental property
that we are now out of the RV and staying in.
Okay.
We are no longer living in the RV and occupying our property.
And what's the date of this text message?
It should be on
It's not, it says Friday.
this past Friday. We literally moved over the weekend. Look, 3 days ago. Oh, 4 days ago.
July 12th.
Yes. I've also been calling the office on multiple occasions, and every time I call, he's out in the field. I have not heard from him since he posted to my front gate on July 2nd.
All right, and let me just take a moment to look at this code section. All right, before I get to that, let me just finish my review here. So, Ms. Katu, before I turn to them, what I see here is that temporary uses that can occur without a permit, and it talks about when the temporary use is construction-related activities, that without a permit, folks can stay for a year with up to 2 one-year extensions, so long as there's an active building permit. But I don't see anything about RVs.
Right. It's a stretch, true. That's what we utilize for that particular criteria, if they have an active building permit, and as they noted on the permit screen, and approval. Our commissioners have actually told staff that they don't want us to approve these if they're in code enforcement for an RV. They don't get that special permission. So in this case, we wouldn't grant it anyway because it's a mobile, but also because of that direction. But they do not have an active building permit anyway, so I can't even consider it.
That's interesting. I mean, because, well, then that means now I want to look at these documents. Does the county have objections to these documents? And if so, what are they and for which documents?
Only as to relevance to the text messages. We understand she hired somebody to clear the land, but again, she's the homeowner, and it's their responsibility to know the code, and she's testified as to that they don't live in the RV any longer, but living on the RV is not a violation before the court, Your Honor, today.
Yeah.
So it has no relevance.
So there's two aspects to any kind of a civil case. One is liability and one is damages or fines. So I understand the point regarding liability, but because all those things are relevant for a fine amount, I will overrule the objections. Let me just take a look at these documents, and I'm going to have trouble sorting them. But the first thing I'm going to do is I'm going to make permit search portal.
She's already labeled 3 of them.
Oh, they are. Oh, yep, I see that.
3 of them.
All right, that's helpful. So I see exhibits A, B, C, D, and E. All right, great. I see them all. They're all labeled. They're all admitted as respondents' exhibits for each case, okay? I'm just going to take a moment to look through them. All right, so one thing I'm going to tell you now is, as I suspected, I see what staff did. I mean, on your permit, on the permit notes, they're not saying that an RV is going to get approved. What they're saying is you have to submit a letter in writing, and what you've heard today is it's going to be rejected if it's the RV. Okay, so I mean, that's what Ms. Coutu said, and that's pursuant to direction from the county commission. So I can't find that the RV is, and it does say here, site review approved, mobile home only. In any event, I just want to let you know my current thought on that. Let me keep going. It looks like you've done about everything you can, except pull the permit. Okay.
I mean, long story short, we hired a company out of good faith,
Oh, I
hoping,
get it.
you know, that they would, if we needed a permit and they would have told us we needed it, it's not even listed in the contract that we needed a permit, we would have paid for it. We would have pulled it ourselves from Polk County. We didn't know.
No, and I take that as undisputed. I think your evidence is clear. And in fact, I mean, you even went to the length, which a lot of people don't, of requesting insurance, business
Yeah,
license,
I
that
asked.
type of thing. I think you did your part. The problem is the code. And in order to be consistent, when someone does something without a permit, whether it's the owner or so I am going to find a violation in that case. The question is the fine, and I'm not going to do as high a fine as you've already heard, okay? Precisely because I do find that you did the best that you could, given the circumstances. Now, I'm not your lawyer. I encourage you to hire a lawyer because maybe you should go after your contractor, maybe for whatever you have to pay here. I'm just, but that's gonna have to be between you and the contractor. Ultimately, what the code says is the owner is responsible. Now, I wanna know what the county's recommendation is on the site clearing case.
A one-time fine of $1,500.
I'm going to, based on what I've seen here, assess a fine of $750. That's because that's the lowest fine I've ever given for one of these cases, because you did come prepared, but the code does make you responsible, as the assistant county attorney said. Now, on the other case, what I'd like to know is, and so that's, let's be specific, that was on case number 24-472. On case number 24-473, I'm going to give you a time to comply before any kind of a fine begins. How much time do you need to bring the property into compliance? Meaning, I assume just grabbing the permit. If they pull the permit, does that bring the property into compliance? Oh, and clear everything off the property?
Yeah, CO.
A CO? How much time do you think will be required between now and obtaining a CO? Do you have any idea?
What is a CO?
A certificate of occupancy, so that basically you can walk in and live at the home that's to be constructed there?
I just told you, we don't even close for another 60 days. We just got our
No, I understand that. My question was, do you have any idea as to how much time you'd need to get a CO? So I understand the closing part, but from total, do you have any idea? And if you don't, that's okay.
They told us between 5 and 6 weeks build time after our closing, so I would assume sometime in mid to late October.
That's what I wanted to know. Ms. Katu, do you have any insight?
I was just gonna say, the CO is usually right out for a mobile home. They get their inspections all at once, and they
Right.
get the CO, so there's not a lag time there, but
And it doesn't take that long to put one of those homes on the property. I
no,
mean,
it's not usually
5 to
days.
6 weeks sounds
That tells me.
optimistic to me, but
It
still.
tells me they must be backed up on their end. When they actually move it on, it's done then.
Oh, I see. So you're
Yeah.
saying, okay, I understand. So today is July 17th?
17th.
Okay, what's the county's recommendation on this case?
$150 a day.
I'm going to find that a violation exists on case number 24-473 and grant 120 days to bring the property into compliance. If it's not brought into compliance within 120 days, I check that, 150 days. 150 days, it'll be a $50 a day fine. Okay? All right.
Thank you.
Good luck.
Thank you.
Next case, Mariah Dolores Kahlo and Ashton Madre, case number 2024-795. Code Officer Brandon Norman, page 8 of your agenda.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you, sir. Please state your name for the record.
Ashton Madre.
Thank you.
Good morning.
Good morning, sir.
Good morning, Brandon Norman, Citrus County Code Compliance Officer. This is for case 202400795, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The address is 214 Hofstra Street, Inverness, Florida. Property owner listed as Dolores Maria Kahlo and Ashton Madre. I have good service via a signed certified mail.
Mr. Madre, are you contesting whether or not a violation exists on the property?
No,
Okay. Are you stipulating to the fact that a violation exists on the property?
now,
Yeah, currently.
well, I did a lot of cleaning up and things like that.
Mr. Norman, did you do an inspection yesterday?
I did an inspection on Monday.
Okay, and was it still out of compliance on Monday?
It was still in violation on
All
Monday.
right. Yeah, in violation is a better phrase.
I did cleaning the day before.
Here's what I would need to know. Let's assume that you may still have a little bit of cleanup to do. How much time would you need to bring the property into compliance?
A month.
A month? Okay, what's the county's recommendation?
We would recommend $150 per day and that you make the respondent responsible to contact us once the violation's been abated so we can reinspect.
So, sir, if you're sure, I'll grant you 30 days to bring the property into compliance.
If you want to give me 2 months, it's fine.
Well, then I'll have to see the photos, and you were testifying that you were close, so I'm not inclined to give 2 months.
I would like for you to see what I did.
All right, then I have to go through the whole case then. Please proceed.
I'm sorry.
It's okay.
I'd like to authenticate the following documents requested to be admitted to evidence is photos taken during an initial inspection on April 23rd, 2024, my corrective action inspection on May 31st, 2024, and my final inspection done Monday, July 15th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt.
All right, sir, let me know if you have any objection to these documents being evidence in this hearing.
And would you mind if we maybe swapped photos, so we did this at the same time?
Sure.
Mr. McGuire, can you look at his photo? Oh, sorry.
Madre,
Norman.
Mr. Madre, would you give the photo? Thank you. And the county will figure out whether it has objections. Mr. Norman, is there a copy of my pre-hearing order in Exhibit B? Okay, all right. Usually you do. Mr. Madre, do you have any objection to these documents?
No, this was before. Yeah.
Well, I understand, but do you have
No.
any objections to them being evidence in this hearing? All right, I take that as, I'm sorry, hold on. I take that as a no. Is there anyone from the public who wants to be heard on this case? All right, Saracen.
Mr. McGuire, when did you take your photos?
Yesterday.
We're not even there yet, so we'll get to that when he wants to introduce them. Okay, without objection, what's been proposed as Exhibits A and B are evidence. Now, I am going to take a quick look at the pre-hearing order. Okay. Please proceed.
On April 23rd, 2024, I conducted an inspection for a complaint of junk and debris. Recently, I did close a case at the same property for the same violation because Mr. Madre had erected a fence preventing me from observing the violation any longer. I was able to gain access to an adjacent lot with the permission of the neighboring property owners, and I found the property to be a violation due to improperly stored junk and debris, household trash, and discarded appliances on the backside of the property. The property remained in violation at my corrective action inspection on May 31st, 2024. I have been in contact with Mr. Madre quite frequently regarding this case. He's been thoroughly informed on how to come into compliance. He's asked several times that we relax our standards, though, due to the fact that he has several other properties that are in violation in Citrus County. I've explained to him that because of the fact that this is my second time with the case, literally weeks apart, he would need to bring the property into compliance if he wanted it closed. As of Monday, July 15th, the property remained in violation.
You have other open cases currently with properties owned by Mr. Madre?
In my zone, I have one additional case, and I am aware of other cases in other zones.
Okay. And what was done to block your ability to see whether there was a violation?
For my previous case, there was a part of the property on the front side, if you're facing the property on the right-hand side, that did not have a fence. When I went to go do a pre-hearing inspection, unfortunately, that fence had been erected on that side.
And that was for a
obstructing my
case
view.
that's been closed out?
It was.
How were you able to close it out?
Because I can't enforce, unfortunately, what I'm unable to see. And I didn't have the access that I had to the adjacent property at that time. The property owners weren't there to give me permission to use their property, so.
And you closed the case?
Because there was.
Is that county policy?
If I can only enforce what I'm able to see, so when people erect fences.
But what you last saw, I'm just curious, and I'm speaking with
Yeah.
you, this is helpful for me to understand.
Mhm.
It's your understanding that you can no longer continue with a case if you can't get access to
Because
see?
I can't provide you the proof that would needed to show that there's still a violation.
Even though
present.
you could have provided proof that there was a violation. You
That there
can't-
was a violation,
But if he
yes.
gets up and says there isn't a violation, what proof do you have to combat that?
Exactly.
Okay, all right, that's the chess game. Interesting. Mr. Madre, do you have exhibits that you want to enter into evidence? These photos? All right. And does the county have an objection to these based on the representation that they were taken yesterday, I think?
Yes.
No objection to the admission. We do have, obviously, comments as to the.
Absolutely. Okay. Then I'm going to admit them on your behalf as Respondents Exhibit A. Let me just take a look. What is that black thing on the ground? Is that a tarp?
That's a covering. I am trying to do a little gardening there, so I put that cloth to kill the grass.
I see. Okay. Okay,
And-
so it's your position that the property's been brought into compliance?
Maybe I have a little more work to do.
Okay.
I just have to tie in with Officer Norman and tell me what else do I need
I
to
mean,
do.
personally, I see just a couple things that look like discarded items in the yard. Maybe two things that aren't like useful gardening type items, but beyond that, it appears to me that the property is currently in compliance. I turn it over to the county if it has questions of the respondent.
Questions?
All right, what's the county's recommendation?
Citrus County Code Compliance respectfully requests that the special master assess a fine of $150 per day along with administrative costs beginning after the date that she deems sufficient to abate this violation. This amount was selected based on the actions of the property owners once they revised the violation and is appropriate given the severity of the violation and the respondent's actions relative to the violation. We'd also ask the special master to find its respondent's responsibility to contact the Code Compliance Division once the violation has been abated in order to allow us for reinspection. And if Mr. Madre would be so kind as to allow me access to, based on those photos, he is very close.
Yeah.
It would make my inspection a lot easier if I could just gain access to his backyard,
Okay.
take a photo, and call it a day.
So, Mr. Madre, here's what I'm going to do. I am going to find that the property remains barely in violation, but there is a very slight violation. It was significantly in violation in April. You've made a lot of progress. However, there is some testimony here that you've got maybe some other violation issues that also need to be cleaned up. So, the county's recommendation is that a fine of $150 be assessed if it's not brought into compliance by the time that I order. I am going to give you time to complete the process here. But in order to, help deter future violations. I'm going to assess a larger fine if it's not brought into compliance now. So I'm going to give you 14 days to bring the property into compliance. There's really not much to be done. You've done a good job up to this point. 14 days to bring the property into compliance. If it's not brought into compliance as ordered, a fine of $300 a day. Okay?
Thank you.
Good luck.
Next case on today's agenda, J&C Gibson Holdings LLC, case number 2024-700. Code Officer Brandon Norman, page 18 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please state your name for the record.
Scott Anderson.
Thank you, sir.
Good morning, Mr. Anderson.
Good morning.
And are you a representative of J&C Gibson Holdings LLC?
I am. I'm actually the Chief Operating Officer for the company, for
Okay.
J.M. Gibson Mechanical, and I'm also the sole owner of Scott Anderson Builders, Inc., which is the general contractor who is doing the work on this property for
All
the
right,
Gibsons.
I accept that as proper standing. Thank you.
Thank you.
Are you contesting whether there's a violation on the property?
I am not.
Okay, now how much, but this is a no development, so from your, what happened?
I'm a 40-year licensed general contractor, but I'm new to Citrus County. And in my ignorance, driving around, seeing lots that were cleared without permit boards, whatever, I made the assumption that I could clear a lot that the Gibsons owned. And I so ordered my company to go do. We have an active building permit in right now waiting for approval. So like any other builder, we like to get a jump on the job. So we cleared the property. Mr. Norman sent the notice. I called Mr. Norman and explained to him the situation, that I had clearly made a mistake. And I'm
Have you been here for the rest of the hearings today?
I have.
So you've seen what normally happens.
I have.
My issue, and so I'm a city attorney myself, and we've passed new rules in some of our cities where they didn't have site clearing permits and things like that.
That's
And
what
now
I'm
they
used to.
do, so it's changing.
Correct.
What's the county's recommendation?
We'd recommend a one-time fine of $2,500. Just to say too, I did try to work with the property owners and allow them some time to finalize the permit process. Unfortunately, due to no action being taken for so long, I had to move forward
What
with
does
it.
that
So,
mean? You said that you wouldn't have brought the case if they
So I
had-
started this case in February, and then they brought another property into compliance for the same violation. So in good faith, I tried to work with them. But they have been very communicative in the process, and they did take ownership of the actions, and were very apologetic. So
We submitted an original permit, and it was rejected because the house didn't fit on the lot. So unfortunately, we had to redesign the house, which is the current permit that it's in. So I'm waiting for approval for that, and we are going to start that house.
Okay, I'll assess a violation, but do an award of fine of $1,500 based on your good faith attempts to comply. Okay, thank you.
Thank you, sir.
Next case on the agenda, Eric T. and Patricia K. Lichtenberger, case number 2024-00767. Code Officer Julie Wilkinson, expert on the case Joanna Coutu. Page 19 of your agenda. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Thank you, ma'am. Please state your name.
Patricia Lichtenberger.
Thank you.
All right, good morning, ma'am. And are you contesting whether a violation has occurred on the property?
I don't know.
Okay, all right, fair enough. County's burden.
I think there probably is.
Yeah.
I just need to know what I need to do.
Let the county present its case, that makes sense.
Okay.
Good morning. Julie Wilkinson, Citrus County Code Compliance Officer. This is case number 2400767. A violation of Citrus County Land Development Code, Section 4002, site development without a development order or permit. The address is 6260 South Redbird Avenue, Lecanto, Florida. The property owner is Eric T. and Patricia K. Lichtenberger. I have good service via signed certified mail return receipt. I would like to authenticate the following documents and request they'd be admitted into evidence. Exhibit A, photos I took during my initial inspection on April 25th, 2024. Photos from a corrective action inspection on May 31st, 2024. And photos from my final inspection on July 16th, 2024. An aerial from the Citrus County, PA, dated May 30th, 2023, and an aerial from the Citrus, PA, dated May 6th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice
I'm
of...
sorry, what was the date of the first aerial?
The first aerial dated was May 30th, 2023.
Okay, thanks.
You're welcome. B, Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, and a copy of the signed certified mail return receipt.
All right. So, ma'am, I'd like to ask you to take a look at these documents and let me know if you have objections to them being evidence. Take your time.
Ah, stuck. Nope, I'm pretty sure that's all accurate.
Okay.
Okay. Oop. Is this one mine or yours? Oh, sorry.
I don't know.
This one, oh, you just
That's
handed me
Exhibit
this,
B,
right?
yes.
Okay.
Okay.
Yes, I've seen it, understand it.
Okay. Without objection, what's been proposed as Exhibits A and B are evidence. And also, is there anyone from the public who wants to be heard on this case? All right, I don't see any response. Go ahead.
I conducted my initial inspection on April 25th, 2024, and observed that the property had been modified. The ground had been graded and large holes have been dug. While researching the property, I observed that there were no permits applied for or issued. I have had contact with the property owner who stated they had no intentions of building anything on the property. As of my final inspection on July 16th, 2024, no permits have been applied for.
It's a great property. I mean, it looks like a nice property, but it also looks like it's been cleared, so.
Okay, so, we purchased this property essentially as a giant dog park.
Wow.
We do retriever training, agility training, and I was just looking for space. There were other properties in that neighborhood that had ponds on them. It is very difficult in Florida to find safe water that's non-alligator infested to do hunt training and retriever training. So I looked for a piece of property that I could dig a pond on.
Yep.
We called the county, asked about permits. They said we needed building plans. I said, I'm not planning on putting a building, you know, maybe in 5 years I might put a little house there, but I was not planning on putting a building. And they said, well, you can't have a building permit unless you have building plans. I was like, well, what do I need to do? And they said, well, you might want to check with Department of DEP and make sure environmental was done. So I went through DEP, I got an environmental exemption.
And when was that? When did you get the environmental exemption?
October 3rd, 2023.
Wow, okay.
And then we went to.
What's the acreage? What's the acreage on this?
It's just under 5 acres. So then we went to the FWC because we knew there were some gopher tortoise mounds there. And I actually had a survey done, paid for the survey. There were 2 burrows that might have been impacted by where we wanted to dig the ponds, so we went ahead and applied to have the tortoises relocated on the same property.
How long did that process take you to get the gopher tortoises moved?
Forever.
I'm curious.
Actually, as it turned out, oh, I don't have the, this is the, okay, that's the application. We finally got the go-ahead that we could start digging, I want to say early last year. I apologize, I do not have that. It took a long time because they have to do the survey, they have to mark where the burrows are, then they have to observe and try and put traps while there weren't any tortoises there. So essentially, I paid $2,000 to relocate tortoises that weren't in the burrows. But neither here nor there. I'm glad. I don't want to hurt them. I mean,
the law's the law.
I get it.
Okay.
Well, I get it, and they're kind of cute. I had names for them.
Yeah, they're wonderful.
Yeah, Grouper and Grunt. Okay.
Developers love them.
Yeah. Well, we're into fishing. So, at any rate, I thought we had everything covered. We hired a contractor who had previously dug technical ponds for a friend of ours. Unfortunately, he was not terribly competent at digging ponds in dry areas, only in wetlands. And that was a lot of money and went south pretty fast. So we went to a second contractor who had a death in the family, and this, I'm listening to everybody's stories, and what I'm seeing with Citrus County contractors is some of them are not necessarily all that on the ball. I honestly did not know that I needed a permit for a building that I'm not building, because every time I called the county, and when I got the notice, I called the county and said, okay, what do I need to do? I need to get a permit.
It's not a building necessarily, but it
They-
includes any development activity on the property.
They couldn't tell me what I need, and I'm fine doing that.
Yeah.
I just they couldn't tell me what to apply
Well, it
for.
includes site clearing, so that's
But
the issue
they told
here.
me I needed building plans to do that.
To do what? To do
To do
a
site
site
clearing.
clearing? That you needed building
I needed
plans.
building plans
Okay.
but since I wasn't building a building. And initially, I was gonna put an outbuilding on there so I could park my RV, and I went through what they did, and, oh, okay, I can't park the RV unless I'm also building a building. But since I wasn't actually building a residence yet, it's like, okay, we scrapped that plan. So
But if
I-
they told you that you needed building plans to do what you did, then, and you aren't putting a building, why did you go ahead and clear the site?
Because I'm not building a building and I couldn't get a permit to build, to do, I mean, so I
see.
own property and I can't do anything with it? And-
You can't materially do anything
Okay,
with
and
it, is what
I
the.
understand
yeah,
that
yeah.
now, but yet if I was running horses on it and I wanted to dig a pond for the horses, I could probably do that because that is an accepted use.
I would
in
always
that
call the
area.
county. I would always call the county to be sure. I mean,
Well,
you-
we did, and they
Okay.
couldn't tell me what to get. They're like, well, I can't give you, if you're not gonna submit building plans, I can't give you a permit. So I didn't know what to do. So I didn't do it. So if you tell me what kind of
do you have
permit I
any
need, I will get it.
applications in currently? Do you
No,
have-
I don't know what to, it's,
Okay.
I don't know what to get. Do I need a special use permit? Do I need, I mean, somebody tell me what the form is, I'll fill it out, I'll pay the fine, I'll pay for the permit. Clearly I'm not trying to get around something, I just am trying to figure out,
I mean, I'm worried,
What to do.
I'll just talk to the county for a second. I'm a little worried by this just because I really don't have any reason to disbelieve her insofar as she's gone to the trouble of getting like environmental exemptions and gopher tortoise, which, as you know, a lot of our people hate to do. I mean, they hate to do that. So it's like, why would she go to all that length and then not? So I don't disbelieve any of that, but I guess my question is,
ignorance
do
is
you
not an
know
excuse.
if the county, is there ever a situation where if someone applies to clear a site that they might be told that they need building plans?
I'll have to defer to the expert.
Well, I'm just curious.
3 times.
And I know you're not there, so you don't necessarily know what people are
Right.
saying.
It's how you ask the question, unfortunately. If you ask for, I want a building permit, then when you need building plans, this would not, as you pointed out, be a building permit. It would be a site improvement or site development plan. It would need engineering.
From a civil,
From a civil point, but you're not going to get it on a vacant lot. So it would be a, no, you can't do this without a principal use. You're in a residential area. You can put a house here.
oh, is this a residential?
Yes, this is entirely residential. She is right on the
Oh.
size, 4.9, but it's rural residential with mobile home allowed.
Okay, now that explains a lot, I think, of the
Okay.
misunderstanding. So they're not going to allow you to do anything that you're intending to do or wanting to do on the property based on its current zoning.
But it
That's-
says it could
and-
be
and
a-
I'm not
it says
done.
it could be a
I'm not
private
done.
park.
I'm not done. And that's
Okay.
why they probably told you that, automatically expected that if you wanted to do anything, you need building plans because it's residential. So what that means is you can't have any kind of accessory use besides the principal use for something in that zoning, which is residential in nature, before you put the principal use in. So you've got to get that principal use established before you start doing the accessory stuff. Does that make any sense?
Does it make sense? Not really. I understand what you're saying. So this property was originally part of a 10-acre parcel, and they had horses on it. So if I wanted to just have horses on it, could I do that?
Well, wait, what is the specific zoning on this property?
It's our resident, RUR.
Residential with mobile homes or RURMH?
Yeah.
Well, so I don't know the answer about the horses. I don't think you can have horses roaming
On vacant land,
on
no.
vacant land without the principal use established.
Correct.
Okay.
And the uses are in 2402.
All right, so if you look at section 2402, we have the list of permissible and probably conditional uses. Let's see. Yeah, rural residential district. So there's things that are automatically, that are just permitted. You still have to go through the process, but single-family homes, accessory structures, passive recreation, croplands, pastures. And so I don't know if some of this stuff might be allowed as a conditional use, but the bottom line is, you can't do any accessory use without the principal. Well, actually, that's not even the violation. The violation is just that there was site plan, or it was cleared without going through the proper process, but.
Okay,
Yeah.
but then I can't use it. You're telling me also that I can't use it.
You're gonna run into trouble, ultimately, if your intention, based on what you want to use the property for, without a principal use at the very least.
Okay. Well, tell me where I go from here, and I am
I encourage you.
beyond upside down in this.
I encourage you to get in touch with the county planning. Is it building department that would work? All right, building that would work with you on what your options are.
So in other words, I need to build a house there, and I need to do it now.
Well, that might be. It's not before me today. Let me say that.
I understand.
So,
Understand.
what's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests a special master assess a one-time fine of $2,500 along with the administrative costs. This amount was selected based on the actions of the property owner once they were advised of the violation.
I mean, I'm gonna lower the fine based on the lengths that I think the owner went through to do everything else, which is rare in my experience. So, but I am going to assess a $1,500 fine. Good luck.
Okay, then what permit, I still need a permit, right?
You've got to get in touch with the building department on this.
Okay.
All right.
Next three cases on the
Apparently I
day's
have to go
agenda.
build a house now. Yippee. Okay,
Michael J.
thank you.
McLaughlin and Mary T. McLaughlin, case numbers 2024-537, 2024-592, and 2024-593, pages 21, 22, and 23 of your agenda.
Good morning, sir.
Good morning.
And what is your name?
Michael McLaughlin.
Okay.
Sir, do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you very much.
Now, all three of these appear to be at the same property. Are they being presented together?
Yes, sir.
Mr. McLaughlin, are you contesting whether or not a violation exists for any of these three cases?
No, sir.
All right. We might have to get into the details, but based on your understanding of what's going on, how much time do you think you'd need to bring the property into compliance on all three of them?
I've partially been working on it since I went through a lengthy eviction process to get this individual off the property. He'd stolen 2 vehicles, an air conditioning condenser, boat motors, stuff that I had on the property. And I've already got the writ of possession.
Wow.
The police served him and got him off, so I am in the process of cleaning it up.
But I guess I just need to know how much time you think you need. So let's talk first of all about
Sure.
the 18-inch brush and undergrowth accumulation of vegetative matter case. How much time do you
That's
need
no
on
big
that?
wiggle. I can take care of that.
I agree. Okay. I mean, I haven't seen the photos, but normally it doesn't take folks
Well,
long.
I'm sure the photos are atrocious.
Okay, and then on the junk, rubbish, debris case, that might be more involved. How much time?
Yeah, I've already gotten a dumpster delivered to the property. We extricated a lot of debris and trash that this individual had, the flatbed trailer that was stolen from the property actually had debris and stuff that I was going to carry to the dump. And they threw the debris off the trailer, stole my flatbed trailer, but I have since cleaned that mess up.
And then on the abandoned, unlicensed, inoperable, junk, disabled, wrecked, et cetera, vehicles.
Well, 2 of the vehicles were already stolen, as well as a flatbed trailer and boat motors and stuff, as I said previously. But the vehicles that are currently on the property aren't abandoned. They're functioning vehicles. They're drivable vehicles. They just don't have a license plates.
Ms. Wilkinson, is that your understanding?
Well, I'm glad you said that because I was only here for the boat in the front because I couldn't confirm for the vehicles in the back. So now we know.
That's correct. I'm sorry to interrupt. The individual that was staying there had 9 pit bulls on the property.
So
and
are
I
you
wasn't
saying
even,
those are the ones that were stolen?
Yes.
Okay.
The boat in the front of the property, the motor was stolen off of it as well.
All right, so what I'm gonna do is let me just ask you this. Do you think 30 days is enough to bring it all into compliance?
It's a handful, but I'll do whatever you grant me.
Let me take a look at the photos. Would you stipulate these into evidence?
Thank you.
I don't want to set you up for failure.
I understand. Thank you very much.
Is there anyone from the public who's going to want to be heard on these cases? Any of the 3? All right. I'm not trying to deprive you of speaking time, Ms. Wilkinson, but there are folks who've been waiting.
Yeah.
These are accurate.
Okay.
The debris pile and everything at the front has already been taken care of.
I understand. We'll admit what's been proposed as Exhibits A and B into evidence on probably all 3 of these cases. I just want to see so that I can gauge how much time. How big is this property?
It's not quite 2 acres, I believe.
Yeah.
1.07 acres.
Okay. Whew. Eeh. All right. Well, so what's the county's recommendation first of all?
$300 a day.
How much?
$300 a day.
Do you have any reason to disbelieve his testimony about the tenant being there?
No, when I was
Okay.
speaking with the neighbors, they said there was also a terrible tenant there before.
Okay, all right. What I'm going to do is I am going to find that the property's in violation in all 3 cases. Case numbers 24-537, 24-593, and 24-592. However, as to case number 24-592 regarding the vehicles, I'll grant 30 days to bring it into compliance. That sounds like it's the easiest of the cases.
Yes, thank you, Special Master.
And we'll do that at $200 a day if it's not brought into compliance within the 30 days.
Might I make a special request? On the property, I have a 1955 Packard. It was my grandfather's. He left it to me after he passed away. The vehicle's currently not running, and it's one of those fixer-upper kind of things. I've had it on the property ever since I've lived there, which has been well over 25 years. I've never had any problems with the neighbors complaining about it or anything else. I would request that I would be able to keep that vehicle on the property.
So the real question is there an exemption for antique vehicles? If it was registered, I mean, what does it, surely something that's registered as an antique with the state would be allowed to stay, but does it have to be operable?
Yes, sir. If it's registered and operable, then it can be on the property.
So otherwise it's just got to go to a museum?
Or be stored in a
Or
garage.
in a garage.
Well, no, I mean, that's what I'm curious about, because what this code section says is, it shall be a violation of this article for any person, firm, or corporation to keep, dump, store, on any property. So I feel like your code section prohibits it even in a garage.
Except for 20-42 exceptions.
Okay,
They shall be
yes.
exempt from this article.
20, where are we, 20-?
20-42,
42.
subsection 2.
Let's look at that. the storage, service, or repair of inoperable or unlicensed that are completely shielded from view or entirely within the confines of a completely enclosed garage, not to include open carports. Does that make sense?
Yes, sir.
So you're protected. You can bring the property into compliance with that vehicle so long as it's completely shielded from view or entirely within the confines of a completely enclosed garage. Okay? So now moving on to case 24-593. I'll grant 60 days from today to bring the property into compliance. If it's not brought into compliance, that will be $300 a day. Okay? But that's 2 months. On case number 24-537, I will also grant 60 days. I don't think 30 days is reasonable. I think you're gonna be working pretty hard, and it will also be $300 a day if it's not brought into compliance. Okay?
Thank you, Special Master.
All right, good luck.
Did you say 60 days on the 537?
Yes.
Okay, thank you.
Should I contact the
Please.
agent involved?
Please stay in close contact.
I'll get her business card or information.
All right, great.
Thank you for your time.
Next case, Thomas Stephen Taylor, case number 2024-942, Code Officer Julie Wilkinson, page 28 of your agenda.
You solemnly swear or affirm that you will tell the truth, the whole truth, and nothing but the truth, so help you God.
Yes, ma'am.
Thank you. Please state your name.
Thomas Taylor.
Thank you.
Good morning, sir.
Good morning.
Julie Wilkinson, Citrus County Code Compliance Officer. This is a repeat violation initially observed on January 10th, 2024. The address of the violation is 6183 West Homosassa Trail in Homosassa, Florida. The case number is 2024-00949, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner is Thomas Stephen Taylor, has previously been found guilty of the same violation at the same location on May 18th, 2023. That case number is 214-2271 with $88,350 in imposed fines. That case was abated on July 27th, 2023. I have good service via posting on the property.
Wait a second. I'm just curious. The previous case was on May 18th, 2023, and then abated on July 27th, little over 2 months later, and it had $88,000 in fines?
I believe I have the incorrect date on here.
Oh, okay.
I apologize for that.
No, that seems a little extreme for me.
2021. Sorry.
Oh, okay. May 18, 2021.
Yeah.
That would make a lot more sense.
I apologize.
Okay. All right.
I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, findings of fact and the order imposing fine and the order acknowledging compliance from previous case number 214-2271. Exhibit B, photos taken during an initial inspection on May 10th, 2024. And photos I took during my subsequent inspections on June 3rd, 7th, 14th, on June 3rd, 7th, 14th, 21st, 28th, July 5th, July 12th, and my final and photos from my final inspection on July 16th, 2024. Exhibit C, a copy of the notice of violation and hearing sent to Thomas Stephen Taylor, a copy of the posting affidavit, and a photo of the notice of violation and hearing posted on the property, a copy of the general pre-hearing order, and a copy of the variance for non-conforming use.
A copy of a variance for a non-conforming use. Okay. All right, sir, I'd like to ask you to take a look at these documents and let me know if you have objections to them being evidence in this case. Please take your time.
Yeah, they said I've cleaned it up since then. I've been cleaning it up daily. Last 2 weeks I've been cleaning up extremely, have I not?
What she's saying is that even if you have been, there's still a violation on the property.
Right.
But regardless, at this point, all I want to know is if you have objections to the documents being evidence for this hearing.
No, I don't know.
Okay. Is there anyone from the public who wants to be heard on this case?
Who's complaining about this?
Well, now, we'll get to that, and you're allowed to ask me, and you can actually, once she's done presenting her case, you can cross-examine her, but give me just a moment. Without objection, what's been proposed as Exhibits A, B, and C are evidence. I'd like to just take a look so I can refamiliarize myself with this. I do remember this case, believe it or not.
I've taken 2 loads to the dump last couple of days. I got 1 more load or 2 more loads right now, but I can't afford to tow it. I got 2 boats on there, and I mean it's clean now, as of this morning. But before she took the picture of me yesterday from today, I gotten 3 more things out of there. 2 vehicles and 2 boats are going, but I can't afford to dump them. I'm trying.
I understand. Well, sir, if you would give me a moment, I just want to look through the prior case to refamiliarize myself with it. Yep, that's why I remember it. My order's a little surprising, though. All right, I'm just going to look through the photos here. This property was brought into compliance before?
Well, when the compliance inspection was conducted, the trailers and all that were parked in a way that obstructed view inside the property and without access to the property.
Are the trailers allowed to be there?
Yes.
Really?
Yes.
Okay.
That's the
V&U.
The V&U. He's allowed to have boats and vehicles and things on his property, not non-conforming use. It's Exhibit C.
Yeah, it's in Exhibit C.
Right.
All right, let me take a look at that. That's fascinating. And more power to you if you can pull that off. Let's see.
He's had it since, I think, 1994.
Okay. All right, let me take a look at it. All right, I think I understand. Please proceed.
An initial inspection was conducted on May 10th, 2024. Scrap metal tarps, tools, bikes, hoses, auto parts, lumber, household items, miscellaneous junk and debris was found on the property. On June 3rd, 2024, I walked the property with the Director of Code Appliance and the Fire Marshal and the property owner, Mr. Taylor, and found the junk had been moved around and organized but remained on the property. The property is a vacant parcel but has a V&U, a variance for non-conforming use, which allows for the storage of vehicles and vessels only. I explained this to Mr. Taylor, and I posted the repeat notice of violation and hearing on the property on June 3rd, 2024. During subsequent inspections on June 7th, 14th, 21st, the 28th, July 5th, July 12th, and the final inspection on July 16th, the property remained in violation.
In the prior case, I want to hear from you, Mr. Taylor, but I just want to discuss with the county what happened before. In the prior case, according to the order, the first order finding that there was a violation, there was testimony regarding a neighbor came to the property and testified that people were living in the RVs and campers on the property, and that there were lights on in at least 4 of the campers, along with a campfire and people coming and going. He stated that everyone in the neighborhood is upset about the conditions at the property. He stated that the sheriff is there constantly for various reasons, and that many of the campers on the property are running electricity from a temporary power pole, which he believes is a fire hazard. Is any of that at issue here, based upon your observation?
On my observation, when I walked the property with the fire marshal and the director, there were a lot of extension cords being they had been disconnected when we were there, but they have been running from one location to all over the property. And most of the RVs were locked with padlocks, but he did give us access to go inside one of the RVs. There was clothing, laptop, and some food items in the RV, but he denied that anybody was living in it. So I can't confirm, but it appears as it may have been occupied.
She entered, I think, 3 of them. You did not? And there
Oh,
was
I
tools
did
in 'em.
enter another one,
Okay.
and it was just being used purely for storage. Did
Tools,
not look
yeah.
to be
Okay.
occupied.
All right, Mr. Taylor, I would like to turn to you. I mean, it looks
feel like
like
living
3 years ago, we went through this, basically. I found that there was a violation, and it wasn't brought into compliance to the best of our knowledge until last year. And so now it's back. I mean, what's going on?
It's clean now. It's gonna stay that way.
Okay.
I'm not gonna make no more messes, period. Anything I bring here or whatever, it will be put up or whatever. I'm not gonna put nothing on the ground no more. That was the problem. I just bring stuff there. I'd clean up houses, and bad stuff to me is good or whatever. I try to do something with it.
Well,
Yeah, I'm
stuff
not
can
doing that
also
now.
accumulate very quickly if people are living there. I mean,
No,
is there?
no, there's no one living there, no.
Okay.
The police have not been out there consistently. The police up, no, they have not.
Okay.
They have not been out there.
Okay.
I'd like to know how many times they've been out there, because they have not.
No, what I was reading was testimony from 3 years ago.
Oh, okay.
So there was an issue apparently 3 years ago. I have no
There was
evidence.
There was one gentleman living there when I bought the property. He stayed there, but he's been gone for a long time.
Okay.
He's been gone.
What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $150 a day, along with the administrative costs to begin the date of the posting of the property, which is June 3rd, 2024, and continue to July 16th, 2024. That would be 44 days at $150 a day, totaling $6,600, and a fine of $250 per day from this day forward until the violation is abated. We would also ask the special master, find that it's a respondent's responsibility to notify Code Compliance Division when the violation has been abated in order to allow for reinspection.
Let's see. So, Mr. Taylor, I'm kind of concerned looking at the photos because as of, I guess, yesterday, well, it does look like there was some improvement, but it doesn't. I mean, would you say, Ms. Wilkinson, that there was improvement in terms of attempts to put stuff on trailers and marshal it and get rid of it?
A lot of stuff was already on trailers to begin with during the initial inspection. Maybe the trailers have been moved around. When I was there yesterday, maybe two trailers were hooked up to vehicles, appearing to maybe being ready to go to the dump, but I don't know if they were taken to the dump or not.
We would also request that you order that Code be allowed to access the property, so he doesn't park an RV or a vehicle in front of the debris and block it from view from the
That's no
road.
problem. I have no problem with that. Did I allow you to come on when you were there? Did I?
Yes.
All right.
I opened the doors for you, did I not?
Yes, he did.
Every door you went to, I opened. Am I right or wrong?
Yes.
And I told you, go inside, please go inside. Didn't I say that?
Yes, he did. He was
Okay.
very cooperative.
I told her, please,
right.
find somebody living here. The one that I worked there, so I go in there, the air conditioning, I'm hot, it's hot in the daytime. I have air conditioning or whatever, even for the dog.
Well, unfortunately, because it is a repeat violation, I am going to find that a violation existed from the time which is June 3rd, and the county's recommended a fine of $150 a day from that time until July 16th. I'll do that for 44 days, and I don't know what the amount is. It's been represented that it's $6,600, but that's fine. So from today's date forward, though, when there's a repeat violation, Mr. Taylor, the problem is there's very few tools that we have to ensure compliance, and one of them is a fine. So if the violation comes back, the fine goes up, is the way it works, at least while I'm here. So from today's date forward, the county's recommended $250. I'm going to make it $400 a day until it's brought into compliance. And hopefully, it's close, but that's the way it's going to be.
Okay.
All right, thank you.
Thank you.
Next case, Tammy Quinetta Turner, case number 2024-579, Code Officer Alan Jonason, page 29 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Oh, and I'm sorry, I'm also going to put a condition in there regarding a condition of compliance that access be allowed. All right.
Thank you.
Yeah.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Yes, I do. Thank you. Please state your name for the record.
Tammy Quinetta Turner.
Thank you.
Good morning, ma'am.
Good morning.
Good morning.
Good morning.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 202400579, Citrus County Land Development Code, Section 4002, Site Development Without a Development Order or Permit. The address of the violation is 1628 East Derby Drive, Citrus Springs, Florida. Property owner is Turner Tammy Quinetta. I hope I said that right.
Alan,
Yes,
the address of the property?
yes,
What did, you said 16?
1628
Wow, okay.
East Derby. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 1 April 2024, photos from my compliance inspection on 24 June 2024, overhead photo from the property appraiser dated 31 May 2023, overhead photos from the property appraiser dated 6 May 2024, and photos of my final inspection conducted on 16 July 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, photos of the notice of hearing posted on the property, and a copy of the pre-hearing order.
So, Ms. Turner, the first thing I want to ask is, are you contesting whether or not a violation has occurred on the property?
This is all new to me, so I don't even know if I have violated.
Fair enough.
or anything.
All right, then step one would be, I'd like to ask you to take a look at these documents and let me
Okay.
know if you object to them being evidence.
It's got the dates on them when they were taken. This was April 1st.
Okay.
Mr. Jonason, have you had contact before today?
I believe I met her briefly on the property.
Okay.
Just verifying the address. Other than that, no.
Gotcha.
Okay.
And that was yesterday.
Okay.
And then these are the notices that were sent, and then as well as photos of the notice posted on the property.
Okay, I only received one notice, that was, I think it was Saturday, I found a thing stuck in my yard.
Sure, yeah.
So I welcome,
Yeah.
so the point right now is, I want you to take a look through these documents if you want, but just to let me know if you have objections to them. I understand you may not have received them. County's saying that they did prepare and/or serve them. And if you want, you'll have a right to examine and cross-examine and ask questions about it. You are saying that you got a notice posted at the property?
Just this one here, a couple
Okay.
of days ago.
Gotcha. All right, thank you. What's been proposed as exhibits A and B is evidence. Just so I know, is there anyone from the public who wants to be heard on this? All right, I don't see anyone. Please proceed.
Yes, sir. On 1 April 2024, I conducted an initial inspection and observed the property to be in violation. On 21 May 2024, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance mentioned earlier. On 24 June 2024, I conducted a compliance inspection at the property as well as conducted research with no permits issued. As of my final inspection on 16 July 2024, the property remains in violation, and I again spoke about the contact that I had with the property owner. I have Joanna Coutu, Land Development, here as the expert witness.
And the site's a little over a third of an acre, 0.35. It is part of the Citrus Springs Master Plan for single-family residential. We do not have any permit applications as of this morning.
Okay. All right, so, Mr. Johnson, the case appears to be that there was some site clearing, I guess?
Yes, sir.
A little bit, that included tree felling or
Yes, sir.
cutting?
Yes, sir.
So what they're saying is that in order to, it appears that there were some trees removed or cut down here. And the reason why I say that is I can see some stumps. I do see a difference between May 23 and May 24. You can tell from the canopy that there's some removal. And what they're saying is that violates the Citrus County Code because in order to do that, you need a permit first. Does that make sense?
Yes, sir.
Do you know if you obtained that permit or have you looked for a permit? I mean, did you get rid of the trees? What happened?
Well, okay, I'm not from Florida, so when I moved here and I
Like most
purchased-
people, most.
and I purchased.
I'm not either. Yeah.
And I purchased the land. This is my first time buying land. I had no idea what I was doing. And so I initially went over there and me and my son started cutting a couple of trees ourselves. We did it ourselves. And I was trying to clear an area because I'm having a cabin, I would say call it, built over there. So then I found out, I went to here. I came here to the building place and I filled out this application to turn it in with them. And they said they would document it, but they told me not to turn it in yet because I needed wet seals from the engineer, which I didn't know I needed. So they highlighted this and told me to go get those done. I showed them the building paperwork for the building structure that I've purchased. And they told me to bring it all back when I get the seals. So.
You've purchased like a home to be built there or installed? Or,
it's like
you said a cabin?
Like a mobile home. They're
Yeah.
gonna bring it over there.
Okay.
Yes, sir. So, so basically that's what I did. And like I said, they told me I needed the wet seals to process the permit. And I actually had, I joined a grant program for my impact fees and everything, which the county has those already.
Wow.
So, I think maybe I was confused at the fact that I can't start doing anything until I actually get the permit in my hand. I
Well, if
didn't
you've
know
been here
that.
today, you will have seen.
Oh, I've learned
this-
a lot today. Yes, sir. I have learned a lot today.
So while you're at it, why don't you take a copy of this, go memorize it, and but I think what it really means is, in order to do something on your property, you've just got to be in touch with the county ahead of time, really, before you do anything.
Okay.
There have been cases where maybe getting rid of half a tree or one tree may not be a violation. Some of us disagree about that, but the point is you can be safe if you talk to the county ahead of time, if that makes sense.
Yes, sir.
What's the county's recommendation?
Citrus County Code Compliance Division respectfully requests the special master assess a one-time fine of $2,500 along with the administrative costs to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the irreversible and irreparable damage caused by the violation.
So based on the photos, I don't really, myself, I understand the case, why it's being called irreparable. I do think it's material. You can see the difference in the canopy. It's, however, it's the least bad violation I've seen today in terms of the clearing. So I'm going to respectfully reduce the fine to $750 as well, based on the testimony. And that's it.
Thank you.
All right.
Can I ask you a question? because I've been hearing a lot of people talk about their RVs. I myself was told that while I'm in the building process, I can have my RV on my land and stay in it. So I want to know before
Personally,
get
I
in
wouldn't
trouble.
bet on it, but what I would do is I would call the county. I mean, it's not for this hearing, and I have no, I'm sorry.
If I may,
Yeah.
you have an existing case for storage on a vacant that was mailed to your Ocala address that you have on the property appraiser?
See, that's the thing, I think is the problem. I'm no longer at that address.
But you have to update. at
You
the
have to
property
update your
appraiser.
address with the property appraiser.
Okay.
And then you would get those notices.
Oh, okay. So you're saying I have to come back
The
here
trailer's
again
gotta come off until you get the building permit, yes. ma'am.
until I get it in my hand?
Yes, ma'am.
Okay, so.
There
I
may
have
be
to-
other things you're allowed to put there, but not that. So, but again, not for this hearing. I encourage you to talk to the county.
All right, thank you.
Thank you for helping. Yep.
Next case, Tomas Vargas and Marcelina Carrillo, case number 2024-956, Code Officer Alan Jonason. Page 30 of your agenda, expert on the case, Land Development Director Joanna Coutu.
Good morning.
Morning.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Thank you very much. Please state your names.
Tomás Carrillo.
Marcelina Carrillo. Thank you.
Good morning again. Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-00956, Citrus County Land Development Code, Section 4002, site development without a development order or permit. Address of the violation is 4619 East Withlacoochee Trail, Denellen, Florida. Property owner is Vargas Thomas Carrillo and Carrillo Marcelina. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Photos taken during my initial inspection on 21 May 2024. Photos from my compliance inspection on 24 June 2024. Overhead aerial photo from the property appraiser website dated 6 May 2024. And photos from my final inspection conducted on 16 July 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, photos of the notice of hearing posted on the property, and a copy of the pre-hearing order.
I have a question for you, Mr. Johnson.
Yes, sir.
So on a case like this, and it should have occurred to me before, but why would y'all go out to a property twice or three times if it's like an irreparable one-time thing?
Well, just to verify that the case is valid. It's just
Okay.
part of our SOP that we continually make those checks.
Okay.
Even though we know the trees
You
aren't
know,
gonna match.
you know on 21 May or 24 May, whenever you first go.
I do, but again, it's our SOP to continue.
If you come out on 24 June, is there anything that could ever change for you about the case?
No, sir.
Okay, all right, just curious.
Well, there could be more continued work or more violations
Okay.
that may start.
Interesting, okay.
Like if there was something stored there.
All right, that makes sense. All right, appreciate it. Sir and ma'am, sir and ma'am, I'd like to ask you to take a look at these documents and let me know if you have objections to them being evidence in this hearing. And you may have your own, but I want you to take a look at these that he's handing you. This is the county's evidence. So let me know if you have objections to it being evidence here. Maybe if you think it's not real or if you think it's inauthentic.
I mean, I contract the guy to clean it up, this property. And I don't know, they told me they can burn up. So I was let him to do it. So they stopped to do it. They stopped to do it, and then they told me, okay, come here, get the permit. And a couple of days later, they told me, oh, I be finished the job. So I have the business card with the people. I'm from Chicago. I don't know nothing but to clean up the property. I bought it. So the land. So this is the company. I contract these people to clean it up. So
You're saying you didn't really do anything, but you hired someone.
I hired someone,
And they
yes.
did not pull the permit.
Exactly.
Right.
So I don't know. They told me, oh, you don't need it. So, if I not need it,
How big is the property?
it's 56.
0.598.
Why are all these contractors, is it just that the contractors don't want to pay, deal with it in terms of the time?
Exactly. But
Okay.
after they come to pick it up, by the permit, they told me and finish the job. So when they finish, I come, I pay after he clean it up.
Well, sir, let me ask you I have to see these things, so let me know if you have objections to these documents that Mr. Jonason is giving you, because I'd like to look at them. If you have objections, let me know. Do you understand?
These pictures.
You want to see it?
No. Do you have any problems with the photos?
No.
Okay,
No, it's right. I don't have no problems.
okay. All right, thank you. Is there anyone from the public who wants to be heard on this case? Okay, all right. All right, then without objection, and are you understanding me okay? ¿Entiendes mis palabras? Okay.
Sí.
All right. Then without objection, I will admit these documents as evidence. Please proceed.
On 21 May 2024, I conducted my initial inspection and observed the property to be in violation. On 21 May 2024, a notice of violation was issued for site development without a development order or permit, which is a violation of the ordinance mentioned earlier. On 24 June 2024, I conducted a compliance inspection at the property as well as conducted research with no permits issued. As of my final inspection on 16 July 2024, the property remains in violation. I have not had contact with the property owner. Joanna Coutu, Land Development Director.
Right, so this is about 0.29 acres. There's several of them, but this is Coastal Lakes Residential. It could have a site-built home, would need the site-built home permit in hand before trees could be removed.
Okay. So the issue here is you can't clear the property without a permit, right? So what's the county's recommendation?
Citrus
Bless- Sorry, I was
No
blessing-
worries.
I
The
was
Citrus
blessing
County,
someone.
it's that PTSD kicking
Yes.
in. Citrus County Code Compliance Division respectfully requests that the special master assess a one-time fine of $5,000 along with the administrative cost to abate the violation. This amount was selected based on the actions of the property owners once they were advised of the violation, as well as the severity and irreversible and irreparable damage caused by the violation.
I'm curious why the max? My understanding is that the maximum fine I can assess is $5,000.
Because it was just completely cut and graded, again, without a permit. It was graded as well as just cut.
I will give you my thought process on this. I want to reserve maximum fines, not just for complete site clearing, but for like aggravating circumstances.
Understood.
Where they're telling you, look, I don't care what their political beliefs are. Maybe they hate it, but F you have no right to, and pointing guns at you. I mean, like, we've actually had facts like this in these hearings. Threats, that kind of thing. I take that into consideration. So, I mean, for all of your officers, I mean, that would be relevant for me if it happens. So I'd like to know how cooperative someone is or not cooperative, that kind of thing. And so I guess what I'm trying to do is telegraph fine levels, and I may not be doing a good job, and you can recommend whatever you want. I'm not telling you what to recommend. But what I'm going to do is find based on circumstances, I think whether it's commercial or residential matters as well. A commercial development, they have more of a reason to know, and often it's more space. Residential, usually it's people just trying to find somewhere ultimately to live.
Sure.
And finding affordable housing is very difficult these days. So I'm less inclined to hammer folks like that. So, anyways, so what I am going to do is I am going to find a violation. Based on your testimony about the contractor, I find that that is a mitigating circumstance and assess a $750 fine.
Thank you.
Okay.
Actually, I have to take Mr. Jonason's point here. It is such a large amount that I'm going to raise the fine to $1,250. There you go. That'll be the fine. Just the whole thing's gone. All right. Thank you.
Thank you.
Next case on today's agenda, Nascimento and Nascimento Investments LLC, case number 2024-926. Code Officer Cody McGuire, page 25 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
What case is this?
202400926.
I'm sorry, what page in my agenda?
25.
All right, thank you. Please proceed.
All right. Cody McGuire, Citrus County Code Compliance Officer, case number 202400926, a violation of Citrus County Land Development Code Section 4002, site development without a development order or permit. Address is 1952 West Adelia Place, Citrus Springs. Property owner is Nascimento. Oh, all right.
Nascimento.
Yes. And Nascimento Investments. Good service via signed certified mail return receipt and posting at the Canto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos I took during my initial inspection on May 9th, 2024. Aerial photos from the Property Purchase Office website. Corrective action inspection on June 4th, 2024, and a pre-hearing inspection on July 16th, 2024. Exhibit B is a copy of the notice of violation, notice of hearing, and a copy of the signed certified mail return receipt and a pre-hearing order.
Actually, I have a question for the county. Now that I'm thinking about it, I wouldn't want to assess a fine that is less than the permit cost under any circumstance. In other words, someone might get the benefit of clearing the property without a permit by getting a fine from me that's less than what they would have had to pay. What are the typical permit costs on cases like this?
Well, they can't get a tree removal permit. It has to be part of a house permit. So on the house permit,
It's based on.
it's thrown in the house permit fees. I want to say it's either 100 or 125. It's very much less than you have.
Wow.
So they're not getting an advantage that way.
Okay, all right, I appreciate
it.
it. All right, thanks. All right, is there anyone here from Nascimento and Nascimento Investments LLC? Is there anyone from the public who wishes to be heard? I don't see anyone from the public left unless I'm mistaken. All right, so you're seeking to introduce Exhibits A and B?
Yes, sir.
All right, I don't have any objections. Exhibits A and B are admitted as evidence. Do you have good service?
Yes, sir.
What's the county's recommendation?
A one-time fine of $1,500.
Completely?
That's the corner lot.
Yeah.
Caro Joao Ferreira.
Raise the fine.
Which is Brazilian. Okay. Do you have any other cases with this company or that you're aware of?
Nothing yet.
All right, then I'll find the property in violation and assess a fine of $1,500.
Thank you.
Next case is on today's agenda. Charles Curry and Victoria K. Cages, case number 2024-970 and 2024-971. Code Officer Brandon Norman, page 11 and 12 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Brandon Norman, Citrus County Co-Compliance Officer. This is for case 202400970, temporary occupancy of a recreational vehicle, violation of Citrus County Land Development Code Section 3140, temporary uses table 3-2, as well as case 202400971, fences, hedges, and walls, a violation of Section 3150 of the Citrus County Land Development Code. Address is 13314 East Shawnee Trail, Inverness, Florida. Property owner listed as Charles M. Curry and Victoria K. Cages. I have good service via signed certified mail return receipt, and I'd like to authenticate the following documents and request it be admitted into evidence. Exhibit A will be photos taken during an initial inspection on May 28th, 2024. My corrective action inspection done on June 13th, 2024. My final inspection done July 15th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, and a copy of the signed certified mail return receipt for both. While the photos may vary in depiction, they are all taken on the same date.
Okay, and that's for both cases.
For both cases.
All right. Without objection, what's proposed as Exhibits A and B in each case are admitted as evidence. Go ahead.
On May 28th, 2024, I conducted an inspection of the property regarding a citation case for junk and debris. I had previously observed an RV in the front yard. On more than one occasion, I observed people entering and exiting the RV. Speaking with Mr. Curry, he did state that there were people living in the RV. I gave Mr. Curry a verbal warning in hopes that it would help me to gain some rapport with him to help me bring my other case into compliance. When I came back out, though, on May 28th, 2024, I noticed that the RV had been moved to the back of the yard, and then they had completed erecting a fence with improper materials. On June 13th, 2024, the property remained in violation. Mr. Curry hasn't told me if, the violation has come to compliance, and he hasn't allowed me to inspect the RVs to ensure that no one is staying in them. And then as of July 15th, 2024, the property remains in violation. I did receive a phone call from Mr. Curry yesterday afternoon stating that there was a death in the family and that he wouldn't be able to make it today.
Is he allowed to have an RV on the property?
He's allowed to have the RV, but the occupation or the occupancy of the RV, that's the violation.
The reason why I ask is because how would you assure compliance? Like, how would you find out if he's brought it into compliance on the temporary use case?
In previous cases, what I've done is I've informed individuals with RVs to make the RV appear as if it is not being lived in, i.e. like pop-outs closed, steps up, no furniture and stuff surrounding the RV. We've done visual inspections before to verify that, it doesn't appear that someone's actively living inside the RV.
Okay.
And then also just their testimony in general.
Then I think what I'll do, I am going to, and I've seen enough.
This is my
I
second
want to
time
hear from
presenting
Mr.
this
too if you
case.
want to testify, but I've seen enough fence cases, and I'm not a master of the code, but I'm familiar enough with the section to see it is improper materials, that I will find a violation in each case. I think maybe on some of these cases I should be putting as a condition of compliance that you should be able to go inspect.
It would be very helpful for us.
Particularly on the temporary use case. I think I have that right I have some injunctive powers in the code. So I'll do that on the temporary use case. What is the county's recommendation as to fines in each?
We'd recommend $150 per day for each case, and that they be responsible to contact us once they come into compliance so that we can allow for reinspection. And then based off your statement, if you have the ability to grant us that ability to verify.
Okay, in case number 24-970 regarding temporary uses, I find that there's a violation. Grant 14 days to bring the property into compliance. And if it's not brought into compliance as ordered, a fine of $150 a day, I will add the special condition as a condition of compliance that you be allowed to inspect and confirm compliance. Regarding case number 24-971, I find that the property is in violation and grant 30 days to bring it into compliance. If it's not brought into compliance as ordered, a fine of $150 a day.
I do have one clarifying question. There are multiple RVs on the property. The only one that I have observed is I can show you pictures from.
If you only have a violation on one, that's the violation.
Mm-hmm, but our ordinance, it doesn't specify which RV is being occupied, so would your...
Yeah, but your case does. Your case is only as to the unpermitted...
So if they move into one of the different RVs,
it's
I
a
would need
different
to...
violation.
Understood. That was my clarifying question.
Yeah.
Okay, thank you.
Yeah.
Next case. Edward Martin May, Michelle Renee Freeman, and Kevin Bracken, case number 2024-918, Code Officer Brandon Norman, page 20 of your agenda. Expert on the case, Land Development Director Joanna Coutu.
Brandon Norman, Citrus County Code Compliance Officer. This is for case 202400918, special requirements for all accessory structures, a violation of Citrus County Land Development Code 3102, subsection A. This is for address 7200 East Turner Camp Road in Inverness, Florida. Property owner listed as Edward Martin May, Michelle Renee Freeman, and Kevin Bracken. I have good service via posting at the property in the Lecanto Government Building, and I'd like to authenticate the following documents to request they be admitted into evidence. Exhibit A will be photos taken during the initial inspection on April 19th, 2024, my corrective action inspection done May 16th, 2024, and my final inspection done June 15th, 2024, or July 15th, 2024. Exhibit B will be a copy of the notice of violation, a copy of the notice of hearing, a copy of the pre-hearing order, a copy of the posting affidavit that I completed, as well as a photo of the posted notice of hearing at the property.
Without objection, what's been proposed as Exhibits A and B are evidence. Yeah, go ahead.
Okay. On April 19th, 2024, initial inspection was conducted of the property for storage on a vacant parcel. 2 sheds were observed on the parcel. They remained in violation of my corrective action inspection. After that, we did have contact with the property owners who said they were going to abate it. As of my inspection on Monday, 1 shed has been removed, but there's still another shed there.
Okay.
And I haven't heard anything else from the property owners since then.
And no permits in progress or anything
No.
like that. Ms. Coutu, do you want to testify, or?
They did once have a permit in 2022. They didn't get inspections. It was canceled as expired in March of 2023. So we have no activity since that time.
Okay. If they got a permit, would the shed possibly be allowed? If it's being used for the tools or
Correct,
stuff?
yeah, we've talked about that before, yes. If they had an active permit, perhaps. In this case, they never even got past an electric pole inspection.
Oh, wow,
So,
okay.
and we rescinded the electric power to the site.
All right. What's the county's recommendation?
Citrus County Code complies with respect to request special master assess a fine of $150 per day, along with the costs along with administrative costs, to begin after the date that's deemed sufficient, and also that the respondents contact us once it's been abated so we can reinspect.
I'll grant 15 days and $150 a day.
Thank you.
Next case on the day's agenda, Nahad Y. Abdel Azi, case number 2024-700, Code Officer Julie Wilkinson, page 5 of your agenda.
Normally, you guys have like 15 after-the-fact permit cases. Is there any reason why they're not on today's agenda, or?
Just none today.
Okay, curious. All right, thanks.
Excuse me. Julie Wilkinson, Citrus County Code Compliance Officer, case number 2300700, unlicensed inoperable vehicle, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The address is 6965 South Sorrel Ave in Homosassa. The property owner is Nahad Y. Abdulaziz. I have good service via signed certified mail return receipt and posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during an initial inspection on April 10th, 2024. A corrective action inspection on May 28th, 2024. An additional inspection on July 8th, 2024. And photos from my final inspection conducted on July 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notice of hearing, a copy of the general pre-hearing order, a copy of the signed certified mail return receipt, a copy of the posting affidavit, and a photo of the notice of hearing posted on the property.
You said an inspection on June 28th?
May 28th,
May 28th, okay.
an additional one on July 8th.
Okay, July 8th, got it, thanks. All right, what's been proposed as Exhibits A and B is evidence. Go ahead.
All right. On April 10th, 2024, I conducted an initial inspection and observed an unlicensed inoperable vehicle on the property. On April 12th, 2024, a notice of violation was issued for an unlicensed vehicles. And on May 28th, 2024, I conducted a corrective action inspection and observed that the unlicensed vehicles remain on the property. I have not had contact with the property owner. As of my final inspection on July 16th, 2024, the unlicensed or inoperable vehicles remain on the property.
Now, you have an Exhibit B. There appears to be a receipt produced June 24th. Is that just a return? Was it signed for?
It's signed for, but it just seemed fishy, so we posted it anyways.
Yeah. Because it does say in your affidavit, I've attempted to serve a notice of hearing. Due to the inability to serve the notice of hearing via certified mail or hand delivery, I posted a copy of the notice. So you say that because you just don't know whether you served it by certified mail.
Well, it was served by certified mail. I just questioned the signature on the receipt.
I would just state that if you're signing an affidavit that you haven't served something.
Oh, okay.
It should be accurate.
I understand.
All right. What is the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day along with the administrative costs to begin after the date you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We'd also ask the special master additionally to find that it is respondent's responsibility to contact the Code Compliance Division when the violation has been abated in order to allow for reinspection.
I will so find, grant 30 days and $100 a day if it's not brought into compliance.
Thank you.
Next two cases on today's agenda, Denise M. Gaho and Carol Wachter, case number 2024-978 and 2024-979. Code Officer Cody McGuire, pages 14 and 15 of your agenda.
Please proceed whenever you're ready.
Thank you. Cody McGuire, Citrus County Code Compliance Officer. Cases number 2024-00978, accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances, and case number 2024-00979, excessive growth and accumulation of vegetation, a violation of Chapter 20, Article 6, Section 20-61 of the Citrus County Code of Ordinances. Address is 6097 North Panda Point, Dunellen. Property owner is Denise M. Gayo and Carol A. Watcher. Good Service is posting at the property and posting at the Canto Government Building. I'd like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during initial inspection on May 20th, 2024. Corrective action inspection on June 4th, 2024. And my final inspection on July 16th, 2024. Exhibit B is a copy of the notice violation, copy of the notice of hearing, copy of the posting affidavit, a photo of the notice of hearing posted on the property, and a pre-hearing order.
Okay. And this is for both cases, correct? Exhibits A and B?
Yes, sir.
All right. They will be admitted as Exhibits A and B in each case. Thank you. I'm sorry? Oh, okay, thanks. You can go ahead.
Okay. On May 20th, I conducted an initial inspection to observe the property to be in violations. A notice of violation was issued for the violations of the ordinance listed above. On June 4th, 2024, I conducted a corrective action inspection and observed that the property remained in violations. I've had no contact with anyone, and as of my final inspection on July 16th, the property remains in violations.
And I think you said, but you haven't had contact with the owner?
No, sir.
Okay.
My original door hanger was left on there during my corrective action inspection.
Now, I'm just curious. Did you do the notice, the affidavit in this case?
Another officer did.
Okay, I mean, why is that?
I was actually out of town.
Okay. I think that's a good reason. What's the county's recommendation?
$150 a day.
All right, in the case number 24-979, I'll grant 14 days to bring the property into compliance. If it's not brought into compliance, a fine of $150 a day. And in case number 24-978, I will grant what would you, I mean, it doesn't appear to be that much.
There's not much.
Okay.
The pool had collapsed on the side during
Do you
my.
consider the pool?
I would now. Before it wasn't. There was a branch that had made that one side collapse. A burn barrel that had been
Okay.
split in two, and there's actually a few flower pots filled with metal debris.
I'm still going to do 14 days on that case based on what I see in the evidence. And if it's not brought into compliance as ordered, $150 a day.
Thank you.
Thanks.
Next case, Merlene and Jesse F. Morgan Jr., case number 2024-969, Code Officer Alan Jonason, page 24 of your agenda.
Alan Jonason, Citrus County Code Compliance Officer. This is case number 2024-00969, unlicensed inoperable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. Address of the violation is 5462 East Tangelo Lane, Inverness, Florida. Property owner is Morgan Merlene L.E. Life Estate and Morgan Jesse F. Jr., remainder without joinder. I have good service via posting the notice of hearing on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request that they be admitted into evidence. Exhibit A, photos taken during my initial inspection on 21 May 2024, photos from a compliance inspection on 24 June 2024, and photos of my final inspection conducted on 16 July 2024. A copy of the notice of violation, a copy of the notice of hearing, a copy of the posting affidavit, photos of the notice of hearing posted on the property, and a copy of the pre-hearing order.
Okay. Exhibits A and B are evidence.
On 21 May 2024, I conducted my initial inspection and observed the property to be in violation. On 21 May 2024, a notice of violation was issued for junkyard conditions, for unlicensed vehicles, which is a violation of the ordinance mentioned earlier. On 24 June 2024, I conducted a compliance inspection and observed that the property remained in violation. I have had contact with the property owner's son. It's an elderly lady that's staying at the home. He indicated that the van was hers and that he had taken the license plate off. He's in Alaska. I guess he does Alaska trips, and he was delivering mail. He called me from the airplane, of all places. Had a great conversation with him, though. He said he'd be back in the next couple of days, and he would get the tag back on there, and that should abate the violation.
Okay. Now that I'm looking at these Exhibit Bs, I just have a question.
Sure.
Can you do certified mail to a P.O. box?
Absolutely.
P.O. box? There's
Absolutely.
something that you can't do with a P.O. box, I thought. I don't remember what it is, but I thought there was maybe it's UPS or something. Now, that wouldn't be right.
No, because it would probably be UPS, but they would leave like a slip in it.
Mm-hmm.
And then you'd have to contact them to come get the package, I guess.
So,
I don't know.
so it says due to the inability to serve the notice of hearing via certified mail. I mean, did you try?
Absolutely.
Okay.
Yeah,
so what happens?
We always send a notice of hearing to the address that's in the property appraiser's website. We send it certified, just like we do the notice of violation.
Sometimes y'all put the non-response in Exhibit B, and I see it. So that's why I was curious.
Well, if we get,
I don't need
usually we just get the envelope back.
Yeah.
With the green piece of paper.
Yeah.
It's not really of much use
No,
other than to say.
if it's in the affidavit, I don't need to see it.
Sure.
I mean, I agree with you.
Yes,
I was just
sir.
curious because sometimes I see it, sometimes I
Yes,
don't.
sir.
So I'm just checking. All right. So what's the county's recommendation?
$50 per day.
30 days, $50 a day.
Thank you.
Thanks.
Next case, Christelle Stiegler, case number 2024-1069, Code Officer Julie Wilkerson, page 27 of your agenda.
Now, I just cannot believe that Ms. Stigler wouldn't want to show up to the hearing. No. There must be something wrong. Okay. Well, if you're watching on YouTube, I would have liked to have heard your defense.
Julie Wilkinson, Citrus County Co-Compliance Officer. This is a repeat violation initially observed on June 7th, 2024. The address of the violation is 6881 West Arlington Place in Homosassa, Florida. The case number is 2024-01069. Accumulation of junk and debris, a violation of Chapter 20, Article 3, Section 20-31A of the Citrus County Code of Ordinances. The property owner is Christelle Stiegler, has been previously found guilty of the same violation at the same location on January 18th, 2023. That case number is 2177612 with $0 in imposed fines. That case was abated on March 27th, 2023. I have good service via posting on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, findings of fact and order acknowledging compliance from previous case number 2177612. Exhibit B, photos taken during initial inspection on June 7th, 2024. Photos I took during subsequent inspections on June 20th, the 24th, July 5th, and July 12th, and photos from my final inspection on July 16th, 2024. Exhibit C, a copy of the notice of violation and hearing sent to Christelle Stiegler, a copy of the posting affidavit and a photo of the notice of violation and hearing posted on the property, and a copy of the general pre-hearing order.
Without objection, exhibits A, B, and C are admitted as evidence. I would like to just take a moment and review the prior order. This must have been the second case. Let me just take a look at the photos. Yeah. All right, please proceed.
I conducted my initial inspection on June 7th, 2024, and observed auto parts, wood pallets, tarps, tools, miscellaneous junk and debris on the property. I spoke with Ms. Stiegler and advised her that the property was in violation and that it was a repeat and what that meant for it being a repeat. I advised her that I would be back to inspect on June 20th, and if it was still in violation, I would post the property for a repeat. I conducted the follow-up inspection on June 20th and found the property remained in violation. On June 21st, 2024, I posted the repeat notice of violation and notice of hearing on the property. During subsequent inspections on June 24th, July 5th, and 12th, the property remained in violation. There has been some improvement in the condition of the property, but as of my final inspection on July 16th, 2024, the property remains in violation.
What do you propose?
The Citrus County Co-Compliance Division respectfully requests that the special master assess a fine of $150 a day along with the administrative costs to begin after the date you deem, beginning the date of the posting of the property on June 21st, 2024, and continue until July 16th, 2024, and that would be 26 days at $150 a day, totaling $3,900. And a fine of $250 per day from this day forward until the violation is abated. We'd also ask the special master to find that it's respondent's responsibility to notify the Code Compliance Division when the violation has been abated in order to allow for reinspection.
Have you found Ms. Stigler cooperative?
She's not cooperative.
Is she combative?
No, she just doesn't communicate.
All right, I'm gonna find that the property is in violation, and I will accept the county's recommendation of a fine of $150 a day to run from the date of posting until July 16th, at whatever total that might be. And from today's date forward, a fine of $500 a day. I make this finding in light of the fact that not only is a repeat on this violation, where in another case today I gave $400 a day, but on the fact that I have personally dealt with this person multiple times, and it's just my only method of coercion is my fines, really. So I'm gonna go up to $500 a day until it's brought into compliance.
Understood, thank you.
Okay, thanks.
Our next two cases we can run together. One's a nuisance case and one's a pool violation. Property owner Elaine Ward, case number 2024-840 and 2024-841. Code Officer Julie Wilkerson, page 31 and 32 of your agenda.
Okay. Julie Wilkinson, Citrus County Co-Compliance Officer. The first case is case number 2400840. Unlicensed and operable vehicles, a violation of Chapter 20, Article 4, Section 20-41 of the Citrus County Code of Ordinances. The second case is case number 24-00841. Residential accessory uses, the Citrus County Land Development Code, Section 3101I. The address is excuse me. The address is 8 Brissanima Circle in Homosassa. The property owner is Elaine Ward. I have good service via posting the NOH on the property and posting at the Lecanto Government Building. I would like to authenticate the following documents and request they be admitted into evidence. Exhibit A, photos taken during the initial inspection on May 8th, 2024. A corrective action inspection on May 28th, 2024, and photos of my final inspection conducted on July 16th, 2024. Exhibit B, a copy of the notice of violation, a copy of the notices of hearing, a copy of the general pre-hearing order, a copy of the posting affidavits, and photos of the notices of hearing posted on the property.
Okay. So I think that's exhibits A and B in each case, and they're admitted as evidence. Thank you. Were you allowed to go on the property to take photos of the car?
I did a postman's walk, so the car's parked in the driveway when I went up to the door to knock the door to attempt to
Right.
make contact.
Okay. Just curious because it's like a really good photo of the tag. And
Yeah.
We don't always get those.
Yeah.
Please proceed.
On May 8th, 2024, I conducted an initial inspection and observed an unlicensed and serviceable vehicle on the property and that a portion of the screen enclosure of the pool was missing, which allows unrestricted access to the pool. This is a safety concern. On May 8th, 2024, a notice of violation was issued for unlicensed vehicles and residential accessory uses. On May 28th, 2024, I conducted a corrective action inspection and observed that the property remained in violation. I have not had contact with the property owner. As of my final inspection on July 16th, 2024, the property remains in violation. This morning, I have had a phone call with the property owner's brother, who has stated that he doesn't know where his sister is, doesn't have contact with her, but he did state because of the safety concern of the pool having unrestricted access that he's going to go over there and fix that.
Okay. I mean, how did he hear about the case?
I called him. He's a local eye doctor. I
Oh.
called his office last week and left
Wow.
a message, and then I called again yesterday, and then he called this morning.
That's above and beyond public service. Okay. So he said that I mean, I'm not holding him to this, but what he represented to you is that he is going to go try and fix the pool issue.
Yeah, he stated he was he was upset that the pool was proposing a danger issue. So he wasn't really concerned about the car, but the pool he was really upset about.
But yeah, the car can't hurt anybody.
Yeah.
And he said he doesn't know where Miss Ward is?
He said she's somewhere in Inverness in an institution.
Okay, all right. Okay, well, the code section is pretty clear about the pools. What's the county's recommendation?
The Citrus County Code Compliance Division respectfully requests that the special master assess a fine of $100 per day for the unlicensed vehicle violation and $500 per day for the residential accessory use violation, along with the administrative costs to begin after the day you deem sufficient to abate this violation. This amount was selected based on the actions of the property owners once they were advised of the violation. We would also ask the special master additionally to find that it is the respondent's responsibility to contact Code Compliance Division when the violation has been abated in order to allow for reinspection.
What was the complaint for?
The original, for the unlicensed vehicle on the pool, it came from a neighbor. So a neighbor has children, and the house has not been lived in for a few years, and it's in disrepair.
Okay, that's useful to know. All right, so on the pool case 24-841, I'll grant 7 days to bring the property into compliance, and if not brought into compliance, $100 a day. It's a relatively shorter amount of time based on the potential safety issues with children around. It's being the summer as well. So case number 24-840, I'll grant 30 days and $100 a day.
Thank you.
Is that the last of the cases?
That's all the cases.
All right, is there anything else that the county wants to take up? Looks like a no. All right, then the time is 12:05. This hearing is adjourned.